Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Alrighty. Hello, and happy Wednesday to everybody. Happy hump day, if you will. If you are watching from the East Coast, this is quite literally the hump of the week. So I'm very happy to see a bunch of people in the chat. Very happy to see a bunch of people, watching outside of the chat even. So we have a really interesting case, obviously, to look at today. And it's interesting because it has a lot of, I think, maybe metaphors is one way to put it. There's a lot of representations, or I should say a lot of people that represent different things to different people in this particular case. We, of course, are talking about the Dave Portnoy defamation case against Insider or Business Insider for a couple of articles that they wrote about him that were supposed to be exposés. He calls them hit pieces, but so we will go through this complaint to see if this is something that is, if it's a legit claim that he has against Insider, or if he's just sort of bloviating, blustering, making sort of BS claims. So I personally don't have any sort of, sorry, Dragon's Treasure. I might be oversteeping this tea a little bit. But I'll get to that too before we actually get into the complaint itself. Like I said, we'll be going through the complaint. I don't have any particular bias one way or another in this case because I don't know. I've not paid too much attention to Barstool Sports, and I also am not a regular reader of Insider. So I don't. I know that there's been some controversies that have come out of Barstool. I know that there's been some controversy surrounding Dave Portnoy, but I don't really have any kind of bias one way or another. So anyway, we're going to look at this as objectively as possible. And before we do, I have some wonderful tea sent to me by the wonderful tea man at the Dragon's Treasure. So I'm probably oversteeping this, but I have two kinds that I wanted to try today. One of them is Uwu. This one right here. This always happens. There we go. There we go. And Sebastian's Morning Earl Grey Vanilla Cream. So I'm trying both of these because I am extra thirsty today because I did a treadmill speed workout earlier, and so I'm pretty dehydrated. So this is actually kind of perfect that I am trying this stuff out. So, and I have this awesome tea steeper teapot thing, which is awesome. And and also I don't even, is that the right way to pronounce it? Uwu? Because I've only ever seen it written. I've never heard it. So correct me if I'm wrong in the chat. But yeah, someone in the chat said that tea is dehydrating. Well, it's better than not having anything, I think. Anyhow, so I don't know if I'm using this particularly properly. Ooh, woo. Yeah, so I did pronounce it right. Okay, thank you. Okay, Google it. Okay, thanks, Dragon's Treasure. Okay, so but this is a really cool thing because you literally you take this and you put it right on top of your cup, and then it just drains right into it. And it's perfect. It's wonderful. Oh shit. Except for if you put too much and then spill it everywhere. Luckily, my laptop is elevated, so I don't have to worry about that. But but that was a big a little bit of a party foul. Okay. Anyhow, so if you guys want to help support the channel, you can also buy from Dragon's Treasure. There's a link in the description below. And you can save 10% and support the channel by using the coupon code Legalbytes. I'm in a competition for the month of February with Eric Hunley. He has his own coupon code for his unstructured channel, for his unstructured podcast. So anyhow, but yeah, but we're competing because whoever can sell more tea per their subscriber count will get like an added like kickback or whatever, for this whole thing. So, anyhow, I really made a mess here, you guys. Okay, now sipping from it is going to be another danger because it's like literally right at the top of the cup. So this is going to be hilarious. At least maybe hilarious to me, maybe just kind of pathetic to everyone else, but that's fine. Anyhow, but yeah, if you guys want to see more ridiculous tea mishaps, buy more tea. So I use more of these during props and stuff. Anyhow, okay, let's get into this complaint, shall we? I'm going to share my screen here. And this is the one thing about StreamYard is wonderful, you guys, except that it is not the best at like setting up multiple screens at once to be shared. So anyhow, okay. So here we go. Here is the complaint. It was literally just filed 2 days ago on Monday. Because there were 2 articles. There was one on November 4th and one on February 2nd. There that came out about these women that said that they had certain intimate encounters, we'll say, with Mr. Portnoy, and they said that they turned violent and non-consensual. So, anyhow, that's the gist of it. And so, he was pretty upset. Yeah, so he was obviously pretty upset and, filed this lawsuit. So, and this was after, by the way, I don't know if you guys are aware, but this was also after. This is weird. This is also weird. Let's try this. This is better. Okay, so this is after he posted a bunch of screenshots of text messages that he had with a lot of these young women, and I say young women because he's in his early 40s, and these women tended to be in their, I think, early 20s. So it's relatively accurate to say that they're younger women, and I don't think anybody disputes that in this particular case. But so he had these screenshots of these conversations that he had with them, and a lot of them were pretty dirty. And he said that he was pretty embarrassed about having to post them, but he felt like he kind of needed to sort of defend himself. So anyhow, let's go through it, and then we'll kind of see how much weight to give to all of these different little pieces. So anyhow, okay. So let's start with what we're going to do is I'm going to go through the introduction here first. You can see here, it's Dave Portnoy versus Insider. Henry Blodget, I believe, is the CEO. Nicholas Carlson is the global editor in chief, and then Julia Black and Melkorka Licea, those are reporters for Insider. Okay, we're going to go through the introduction, and then we're going to go through sort of what we need to be looking at as we are in order to analyze a complaint, I should say. So what we should be looking at, what makes a good complaint, what doesn't make a good complaint, and then we'll go through the actual charges and whatnot, or the causes of action. So anyhow, let's do this. Introduction. This case arises from defendant's knowing publication of 2 false and defamatory exposés into the private life of the well-known founder of Barstool Sports, plaintiff David Portnoy, Mr. Portnoy. On February 3rd, 2022, a representative for Defendant Insider, Inc., or Insider, gave an interview to Variety boasting, "If we get sued, we will defend the case vigorously. News organizations regularly get sued. It's the cost of doing business." I mean, that's probably true. I would imagine that most journalistic outlets would probably expect to be sued from time to time, because otherwise, then they probably see them as not doing their proper job if they're not ruffling feathers enough to be, claiming. Anyhow, you know the thing. Perhaps it is the cost of doing business for Insider, a publication that generates its revenue through clickbait journalism and the publication of false and defamatory hit pieces concerning the country's most well-known figures. To Insider, the truth has always played second fiddle to the dollar. Okay, that's fair, but it's a little bit, it's a little bit blustery, I guess you could say. But hey, maybe he's right. Defendants published as fact that Mr. Portnoy had violently AR'd and intimately assaulted. I'm gonna modify these words a little bit for anybody that is listening on the podcast. I'm modifying the words that I'm reading off of the page here from the complaint, just because I don't want it to get too demonetized. Okay, so anyway, so they published as fact that Mr. Portnoy had violently AR'd and sexually assaulted, there I said it, 3 unnamed females in outright fabrication. Defendants perpetrated their hit pieces as part of a preconceived plan to sensationalize a story in order to drive reader traffic to an internet location where they could then be solicited to subscribe to defendants' tabloid-like publication. Further demonstrating defendants' malicious intent, each of Insider's stories was published on a date coinciding with Penn National Gaming's quarterly earnings announcements. In parentheses, Penn National Gaming owns a 36% stake in Barstool Sports. Defendants' actions were outside any conceivable notion of actual journalism. Mr. Portnoy seeks to hold defendants accountable for their willful and unlawful defamation and privacy rights violations. So, this part about the Penn National Gaming's quarterly earnings announcements, that's interesting. It's interesting because it seems like they're going to be suggesting that that they're not just trying to hurt his reputation, but also hurt Portnoy's financial pocketbook, particularly because of the fact that he's the founder of Barstool Sports. And if anybody is somehow unaware, Barstool Sports is an online, I mean, I guess you could say website, but they have like other like YouTube channels and like that kind of stuff. But like I think mostly centered on a website. Started particularly about sports, but it's like sports and pop culture. Portnoy himself describes it, I think, as like a sports / smut kind of publication. So, but there are 2 big investors. Penn National Gaming is one of them. I can't remember the name of the other. Maybe someone in the chat will know. Someone in the chat will probably know. So yeah, Chris Azera says sports and entertainment. That's true. Yeah. So, okay. Defendants calculated that canceling Mr. Portnoy would be a lucrative business for Insider. Insider and its staff were willing to cash in on their stories while knowingly disregarding the truth. In publishing the false and defamatory stories aimed at destroying Mr. Portnoy's reputation, Insider sought to cause the downfall of one of Massachusetts' most well-known entrepreneurs and media personalities. Indeed, Mr. Portnoy's life has been nothing short of remarkable. In 2003, in Milton, Massachusetts, Mr. Portnoy created a small sports newspaper named Barstool Sports. In the publication's early days, Mr. Portnoy self-authored and printed the newspaper's first issues and distributed them to commuters on the Boston subway system. Since its humble beginnings 18 years ago, and under Mr. Portnoy's leadership, Barstool Sports has become one of the most widely known sports media and pop culture enterprises in the world. Because of Mr. Portnoy's celebrity and notoriety, Insider viewed him as the perfect target for its false, albeit scandalous, hit pieces into a celebrity's private life. Insider's defamatory scheme was well planned and nearly a year in the making, and the defamatory stories would serve as the launch for Insider's promotion on discounted premium subscriptions to its online publication, Business Insider. So, 2 points about that paragraph. Number one, he's referring to himself as a well-known person. So this means for defamation cases, we are going to be, I'm going to talk about all of the different elements of defamation, but in this particular case, we're going to talk about actual malice because that is the standard that is required for people that are well-known, that are household names, et cetera, et cetera. So famous people that put themselves out there in the limelight and then become very well-known. That's different than the standard that would be for any regular person that's filing a lawsuit for defamation. And then number two is it seems like they're suggesting here so far that that insider had a particular financial reason to do all of this, and that is to build up their their own business. So for business purposes, in order to profit from him, that is potentially going to go towards seeking punitive damages. We saw this in, excuse me. We saw this in the Cardi B lawsuit when Cardi B sued Tasha K for making all kinds of defamatory statements against her, and she 100% won because Tasha K basically admitted on the stand, yes, I lied about everything. I pretty much knew that what I was saying was false, and I said it anyway. I didn't really care. And oh, by the way, this is my business. This is what I do. This is sorry that you are harmed by this, but that's what I do for my business. I make money this way. And that set her up for not only being liable for defamation, but also for punitive damages on top of that, because that's like you're profiting on top of it. You're not just saying it and oh, oops. You're saying it and then you're making money from it. That's something that could potentially open you up to more damages on top of normal compensatory damages. So, turning back, without a modicum of journalistic integrity, with Insider's Chief Executive Officer Henry Blodget at the helm, Insider, its reporters Julia Black and Melkorka Licea, and their editor Nicholas Carlson, collectively defendants, engaged in a calculated smear campaign against Mr. Portnoy by publishing and thereafter refusing to retract and or correct 2 false and defamatory stories on its website, at least suggesting, if not blatantly stating, that Mr. Portnoy sexually assaulted 3 women. Insider's allegations are patently false and, critically, are belied by the evidence actually in Insider's possession. Ooh, okay. That's, if that is true, that they had certain exculpatory evidence that would suggest that what they were saying is not true, that is something that is particularly interesting in this case and would be very, very helpful to his claims. So, paragraph 5 says, over the last 10 months, defendants have engaged in targeted smear campaign designed to destroy Mr. Portnoy's reputation and boost Insider's viewership and subscription revenue, which includes the following. Paragraph 1, or subparagraph 1, defendants knowingly and repeatedly published 2 false standalone headlines to lure readers and potential subscribers to their website, stating, for example, quote, I was literally screaming in pain. Young women say they met Barstool Sports founder Dave Portnoy for sex, and it turned violent and humiliating. There should be, oh yeah, unquote. Okay, Insider thereby suggested actual criminal wrongdoing on Mr. Portnoy's part without further explanation, a tactic which is known as clickbait journalism, giving rise to a claim here for clickbait defamation. So I think that the suggestion here is that because there was a paywall that interfered with the general public reading the actual article, the statement in the title alone is defamatory, according to Portnoy. I think that there's a possibility there. There's a suggestion that if it turned violent and humiliating, I mean, it doesn't necessarily say explicitly that it turned criminal, but it seems like that's suggesting that there's a criminal a criminal element in there, which is potentially defamatory. So, but this is what this is going for, is to say that it's not just people who subscribe to Insider that saw this article, that saw the defamatory content in this article. What this would be suggesting is that anyone who saw that headline, regardless of whether they pay the money to Insider to get past the paywall, regardless of that, all of the people that saw the title alone would have had that reputational mindset change of Dave Portnoy, which I think is potentially true, because I think I remember seeing the initial headline and thinking like, oh wow, that's pretty nuts. So, okay. So, subparagraph 2, it says, defendants published directly and via innuendo that Mr. Portnoy had committed the crimes of R, intimate assault, and surreptitious recording while in possession of text and social media messages showing just the opposite. Okay. Defendants pursued a preconceived and biased agenda aimed at damaging Mr. Portnoy to drive online traffic and subscription revenue to Insider. 4, defendants improperly and knowingly relied upon biased sources who demanded anonymity, all while being in possession of documentary evidence that each source's story was incredible and unreliable. And 5, defendants published highly personal and private information in violation of the Massachusetts privacy statute and Mr. Portnoy's common law right of privacy, while affording confidentiality and anonymity to defendants' alleged sources. All right. Mr. Portnoy has never intimately assaulted anyone, and defendants are well aware of this fact. Nevertheless, Insider is attempting to cash in on the climate of fear and cancel culture permeating the media, whereby it has become open season for anyone to make any claim, no matter how vile and unsupported, about anyone seemingly without consequence. There are, however, consequences for unlawfully defaming someone. Well, that is true. If you can prove defamation. Mr. Portnoy will not stand idly by while Insider and its Twitter army of executives, editors, and reporters attempt to drive clicks, viewership, and subscription revenue for themselves by recklessly spreading malicious and defamatory lies that Mr. Portnoy engaged in egregious criminal conduct by sexually assaulting 3 women and or recording them without their knowledge or consent. Even after being confronted with the exculpatory evidence that contradicts the maelstrom of false allegations in its stories, rather than admitting to its misconduct and irresponsible journalism, Insider refused to retract, correct, or even update its stories about Mr. Portnoy and is instead maliciously standing by its false and defamatory reporting. Now, months after its initial publication, Insider continues to use Portnoy as bait to attract consumers to its subscription service. Insider's conduct here is shameful, but given defendants' track records, it is not surprising. Mr. Portnoy brings this action to clear his name, to set the record straight, and to recover the substantial damages that defendants caused him as a result of the irresponsible and defamatory stories they published about him. Whew. Okay, so that is the introduction here. And we're going to get into some of the details of each article as it comes up in the complaint. But first, I want to go over the elements of defamation and invasion of privacy under Massachusetts law. So that way we can kind of track as we're going through here whether or not this complaint is any good. So let's do this. Aha. Okay. Here we go. Defamation and invasion of privacy. Okay. So the elements of defamation are first, and by the elements, I mean, this is what a plaintiff has to prove in a case like this. So this is what Portnoy has to prove. And in a complaint, you have to show that you are alleging enough facts to basically check each of these boxes. Hey, Kurt. Hey, Uncivil Law. How's it going? If you want to join me, I can send you a link to the StreamYard to get in on this with me. But if not, that's cool too. Anyhow, just let me know either way. So for a complaint, oh, okay, sure, why not? All right, cool. Give me just a second, guys. I'm gonna send him a link right here. All right. It's in your DMs, Kurt. All right. So for a complaint to be good, for a complaint to be any good, it has to survive what's called a motion to dismiss. So basically a motion to dismiss is going to, if let's say insider can choose to either respond with an answer or a motion to dismiss. And an answer, basically they just go through and say whether they admit or deny certain things line by line. Option number two would be a motion to dismiss, where they say, nope, this case should go away because there's no cognizable claim here. It's not, there's no plausible claim here that this case could go forward. And well, hello. How are you?
Hello, I'm having a great morning. How are you?
I'm doing well. I'm drinking a lot of tea. I'm spilling it everywhere.
Yes. I'm supporting you in this competition.
Thank you. Thank you. I appreciate that.
I have enjoyed the Dragon's Treasure tea as well. I got a whole little sampling of tea, and I think it's very good tea, genuinely.
Yeah.
And so I recommend it for people who are tea drinkers. I think you will find it quite enjoyable. There's quite a lot of varieties of tea. Yeah. So make sure to check out Dragon's Treasure and use the code, what is it, Legalbytes for you?
Yep.
So use the code Legalbytes so she can win this competition because she deserves it.
Aw, thanks. I mean, not to say that Eric Hunley.
That was what I was saying.
No, he deserves it too, but we're competing, so I want to win. Yeah, no, these are good. These are really good teas. And I'm very happy that I didn't spill it on myself a second time since it was like up to the very top.
Mm-hmm.
Anyhow, so okay. So I was just going to go through the elements of defamation. And hey, lawyer, hey, how's it going?
I don't know lawyer, yet. I think he reached out to me to try a collab, and I need to get back with him. So DM me on Twitter or something.
No, I know. Yeah, let's definitely collab soon. I'm so sorry. I need to respond to your email. So yeah, but
send me an email as well. It's uncivillawYT@gmail.com. So
there you go.
You can send me an email. We can collab. So
yeah, for sure.
Yeah. Pressing on with things I haven't followed up on.
So yeah. That'll be fantastic. Also, if lawyer, if you want to jump in, I can also send you a DM.
That'd be good. Why not collab right now?
Yeah, why not? We can talk about this case. If you'd rather not right now, that's fine. Okay, so let's get into the elements of defamation and invasion of privacy. Those are the two main claims here. Defamation. First, he has to show that the defendant made a false statement about plaintiff. The defendant made the statement to a third party, and the defendant normally did so negligently, but here it's with actual malice. Fourth, that the plaintiff's reputation suffered a harm. Fifth, that the plaintiff's reputational harm was caused by defendant's statement. And sixth, technically, defendant has no privileges that he or she can use as a shield to liability. So, for example, like if you've got some congressman on the floor of the Senate or the House, generally speaking, those kind of statements that are made on the floor, I believe, are immune from defamation.
Yes, they are. Yes, everything said on the House floor is immune by constitutional rule.
Yes. So you could, somebody could get up there and say, I don't know, Ted Cruz is a, hoe bag or something. I don't know. And I'm not saying that, but
technically speaking,
what came to mind.
Get up there and spill state secrets. They're classified information and they can't be prosecuted. Ooh. It's hilarious.
Oh my. Yeah.
And they're totally immune for anything said on the floor.
Okay, yeah. So, but in this particular case, I don't think we're looking at any kind of privileges. And
other privileges, more common privileges would be like I'm communicating to my spouse, who would technically be a third party. I'm communicating to my doctor, psychiatrist. I'm communicating to my lawyer. So those would be more common, or communicating to my priest. So those would be more common privileged communications.
Yeah. So in this case, defendant made, what we've seen so far from the introduction, has the defendant made a false statement about plaintiff. So when we are looking at a complaint, we are not determining whether or not what's been stated as, as an allegation is true or false. We are accepting it as true. We're automatically accepting it as true. And then we're just saying, like, have they made a statement basically meeting this meeting this element? And
Right.
so far, yes, he says that they've made false statements about him R-ing or intimately assaulting multiple women, and he says that is false. So number two, they made a statement to a third party. Yeah, they published it publicly to the world through the major publication. So did they do so with actual malice? So the definition of actual malice is that they have to have either known or been reckless as to the truth or falsity of the statement, and they went ahead and did it anyway. So for example, Tasha K in the Cardi B lawsuit said just about exactly that. She said,
I did it falsely. I knew it was false.
Yeah. She said,
yeah.
I mean, it was like, she's like, yeah, the actual definition of actual malice. That's what I did.
That. Yeah. It's pretty hard to prove, but when you get up there and be like, yes, I lied. I did it purposely to make money. I did it for the money. Yeah,
exactly.
That'll do it.
Yeah, exactly. So in this case, this is what Dave Portnoy says, is that he says that they have evidence on hand that what they did or that what they said was not true. So they have text messages. At
the risk of saying a bizarre question, does he have evidence that they have evidence, or is he speculating this evidence into existence?
So I think part of it is that I think it's before the second article. I think that he had a chance to give them text messages or something like that, something along those lines. And I believe that his attorney spoke with their attorney and kind of.
Okay, that's the kind of thing I'm looking for. I'm looking for something that we have a reason to know that he knows. Yeah. And I communicated them and gave them information is certainly very helpful towards that end.
Yeah. Yeah.
But by the same token, though, just if I said something about you and you communicated to me and told me that was false, it doesn't inherently necessarily make it actual malice, because you're obviously self-interested. And so I might have reason to disbelieve you. Yeah. So it would depend a lot on the nature of what you told me. If you just called me and said this is false, and I'm like, well, I'm just ignoring your self-serving statement. That's not what actual malice looks like.
Right. Right. So yeah, you would need to show more. But at this particular point in time in the complaint, he doesn't necessarily need to throw out all of the evidence that he has. He just needs to allege it. He needs something. He needs to allege it. He needs to show some, like it's we can even look at the text messages, the screenshots or whatever that he, if he provided those to them at a time, and we can look at those and say, I mean, someone actually could look at these and still think that something happened, that doesn't matter, because the fact that he has certain things that he says that he provided to them, that's enough for him to meet the burden to get past a motion to dismiss. And that would get him into discovery, which means that this is like the two sides are passing information. This is like the expenses of litigation go dramatically up after the pleading stage, when you get into the discovery stage. So
I mean, I think to some degree it depends on the state. If they have an anti-SLAPP, so are we in a state with an anti-SLAPP is a good question.
Oh, I didn't.
Because the anti-SLAPP is a strategic lawsuit against public participation, and it's most common in defamation. Basically, you are trying to sue someone just because basically they're saying mean things. So you're using the expense of the court process as a tool to silence them. And a lot of states have an anti-SLAPP to prevent this, and varying degrees of success. But some states, like Texas, I think is particularly strong on this. You have to show clear and it's not clear and convincing. It's clear and something else. Clear and some other kind of evidence that it's true. So it's a bit of an elevated standard. And if you can't meet it, you can get attorney's fees. So there's that too. Yeah. And this is one of the reasons I think that maybe his mere saying I gave them things might not be sufficient depending on what state we're in.
That's a very good point. I didn't think to bring up anti-SLAPP and I should have.
Well, that's okay. I'm here to raise issues.
Yes, I appreciate it.
No problem.
So let's go back to the
clear and specific. That sounds about right. Yeah, it isn't clear and convincing. Clear and convincing is a different legal standard. I know it wasn't that. Clear and specific sounds right. Okay, thank you.
There we go.
There you go.
So for elements 4 and 5, we're talking about the reputational harm, and then we're talking about causation of that harm. So not only that he suffered harm following the publishing of this statement, but also that the harm wasn't caused by something else that he did someplace else, right? Causation. But what I didn't note in these elements is that there's also something called defamation per se, and Massachusetts law also does have they do allow for defamation per se, which basically says that there are certain lies that are so terrible that we are assuming that there is reputational harm. Cardi B, that was a situation where they were alleging defamation per se because they were talking about drug use, crimes, and prostitution and all kinds of crazy stuff. That is definitely, I mean, like, yeah, like you hear about that and you're like, ooh, yeah, that's pretty terrible. Pretty terrible. So what we're talking about here are multiple different kinds of potential criminal activity that is particularly egregious, right? Intimate assault, R-ing someone. And then also, it doesn't say it in the introduction, but later on we'll get into his recording of people. That was also alleged in these articles. These are things that sound a bit like crimes, right? So Massachusetts law does allow for defamation per se when we are talking about crimes. So here looks to me so far like we've got defamation issues. So invasion of privacy. This is a statute in Massachusetts. I should have put the statute name and section, but basically it's pretty simple. He has to show that the defendant disclosed facts about him. Okay, yeah, we have that. That those facts were highly personal and intimate. Yeah, it doesn't really get more intimate than that, right? And then third, that the defendant had no legitimate countervailing interest. So the question is, it's like element 3 kind of goes hand in hand as to whether or not the facts were true or not, right? Or if they had reason to believe that they were true or not.
Can I push back a little bit on factor 2? What facts are you saying are highly personal and intimate?
His sex life.
But these are okay. Are the state? I'm a little bit unclear on the facts here. Are the statements about, to the extent that they're alleging assaults that occurred on other people, then I'm not sure that would necessarily qualify. If they're talking about consensual acts, I think they would be. But
that's the whole thing, right? Is that he says that they were all consensual, and the insider articles say that they maybe started consensual, but ended up not consensual and turned very violent. So it's like it kind of turns on this invasion of privacy claim, kind of turns on the defamation. It's like he's either going to win both or neither.
Yeah, I mean, that's very, very typically true, that they tend to rise and fall together.
Yeah. So in this particular one, I mean, he hasn't quite said yet that they had no legitimate countervailing interest, but
I think on 3 you have an issue there, because if we're talking about, again, forcible assaults and things like that, I don't think there's a legitimate countervailing interest in exposing that. So, but then again, it depends on it being true.
Yeah. So that's really what it comes down to, right? Because they would have a legitimate countervailing interest if what they're doing is just sort of exposing, like, because what they basically say is that they're like exposing this power dynamic thing, that he's this famous, powerful man who's a multimillionaire, and he's like twice the age of these women that he's sleeping with. And so there's like this big power dynamic that they are reporting on, and they are, talking about these women that are being assaulted in various ways. They're being recorded against their will. They're being, this and that and the other thing. Yeah. So that's they say that they have a legitimate interest in or they would say that they have a legitimate interest in this to do their job and to sort of expose these powerful people and the things that they are doing. You know, like you can kind of think of like somebody exposing Epstein, you know, to say that like the things that he's doing are terrible and criminal and whatnot. Because otherwise no reporter would ever be able to expose the more egregious sort of crimes that people commit. So, but it kind of comes down to whether or not these things are criminal or not, whether or not there was consent, whether or not there was consent for recordings. So
is Massachusetts a state requires it? It probably does, but I just thought I'd double check.
Massachusetts, for recordings.
Yeah.
It is a two-party. It is a two-party. And let me
yeah, I figured it probably was, but it was worth double checking.
Yeah. I'll share my screen here again. On a different page. Here we go. I really wish that I could just set up all of these ahead of time. But so this is the Digital Media Law Project. I've seen some of their other stuff on like on defamation, some of their other pages. Generally speaking, they've been pretty good. But this is about Massachusetts wiretapping law. Massachusetts wiretapping law often referred to often referred to a two-party consent law. More accurately, Massachusetts makes it a crime to secretly record a conversation, whether the conversation is in person or taking place by telephone or another medium. Accordingly, if you are operating in Massachusetts, you should always inform all parties to a telephone call or conversation that you are recording, unless it is absolutely clear to everyone involved that you are recording. Under Massachusetts wiretapping law, if a party to a conversation is aware that you are recording and does not want to be recorded, it is up to that person to leave the conversation. So this is kind of where we get into, you know, how the law helps those who help themselves. You know, that concept that like, if you don't want someone to be recording you in a state like Massachusetts, or, you know, California is a two-party consent state, and you know that someone's recording and you're continuing on with it, that is implicitly consenting.
Correct.
So, you know, you can't later on say, well, I didn't want it. You got to say something. And that's just the fact of where the law stands, because the law doesn't allow for people to, you know, make other people guess into their state of mind. You know, if they don't say or do something that indicates that they are not consenting, especially relatively clearly. So, I think that that's probably going to be relevant moving forward with this complaint. So, shall we get into some of the more detail-y details?
Sure.
All right. Let me go back to here we go. Okay, back to the complaint. Okay, so we're going to skip past the parties and the jurisdiction and venue because that's all boring stuff, and I already explained who everybody is. So, okay, we basically have, I mean, these paragraphs I think we can probably skip through because it's basically, you know, how they talked about how they sort of approached him ahead of time before they published the first article and said, oh, there's no real angle. Do you want to comment on your life or whatever? And he was like, no, thanks. And then they were like, okay. And then like 8 months later, after I guess investigating that entire time, then he finds that they have published an article. On November 4th, 2021, defendants published their first defamatory hit piece on businessinsider.com titled, I was literally screaming in pain. Young women say they met Barstool Sports founder Dave Portnoy for sex and it turned violent and humiliating. And then he calls it the first story. For search engine optimization and clickbait purposes, the first story's URL included words Portnoy, choking, violent, sex, and stoolies, collectively the URL tags. Further, the first story was published behind a paywall, requiring readers to sign up for Insider's paid subscription service to access it. This revenue-generating scheme was all part of defendants' nefarious plan. So, defendants knowingly and repeatedly published the false standalone headline, including its publication of the URL tags, to lure readers and potential subscribers to their website, thereby suggesting actual criminal wrongdoing on Mr. Portnoy's part without further explanation. Defendants' conduct constitutes a tactic known as clickbait journalism, giving the rise to a claim here for clickbait defamation. What do you think about that particular claim, Kurt? The idea that this title alone is enough for defamation.
Well, I don't know the title in and of itself would necessarily be defamatory, but what I would say is that the title would necessarily influence the rest of the article. I think defamation always has to be understood in its entire context. You can't just take a sentence or a line from a broader work and say this line is defamatory. It always has to be understood in its entirety. So I think this would prime
because
prime them to think one thing, but the article itself might be more cautious.
Okay, that's fair. So because and sorry, I was starting to interrupt you, but the taking it into context, that's correct, because let's take stand-up comedians, for example. You could have one line that sounds like it's completely defamatory against a particular individual, but then it's in the middle of a context of a whole story that is much less so. And then you can tell by the context that it's satire, it's for humor. No one would really believe that statement was made as a representation of fact. So that kind of thing. So that's a very good point. I think that the point that they're trying to get to by saying that in this particular lawsuit is that because there are only a certain number of people that pay to get past the paywall on Insider, that Insider would try to say, well, the damages are much lower because only so many people are subscribers, and that's what the cap viewers are for that particular article. So, but I think that his point is to say that no, like anyone who saw that article and couldn't get into the actual heart of the article itself is also going to have their impression changed because of the nature of that title.
Okay. Yeah, then in that case, the title could be reasonably understood to be standing alone. Then one question I would have is how many people actually read, because it's inside the URL. So how many people really saw that or really read it? I mean, it's not, you don't normally, like when you're clicking on something, think about the URL. So I don't know how many people would necessarily saw it at all.
Yeah, the URL part, I don't know. Like, I don't usually pay attention to the particular URL of any article that I read. So like unless I'm, I don't know, copy pasting it for some reason, but I usually don't pay attention to that. But the title itself, though, I don't know. The title itself could be, I think it could be potentially defamatory.
Yeah, so. I'm not sold, but let's press on.
Okay. All right. I mean, at the very least, for purposes of a complaint and a motion to dismiss, like getting past a motion to dismiss, I think it states enough there that they could let it proceed. So, adding insult to injury, the first story contained alleged screenshots and quotations from Mr. Portnoy's private text and social media messages in violation of his privacy rights.
I don't like that. I don't like the word alleged here for because they're the ones saying this is an invasion of privacy. It can only be an invasion of privacy if they are in fact screenshots and quotations from his private text messages. If they're not, then they're not, unless they're just, I don't quite like that. I don't like the word alleged here.
Okay. Interesting.
Am I wrong on this? I'm saying that you defamed me by alleged screenshots. Well, are they or are they not? I mean, I would know. They're my screenshots or not.
Yeah.
I mean, I would know if those are authentic.
Although, hang on, the screenshots aren't necessarily from conversations that he had with these women. I from browsing through this complaint earlier, there are screenshots that the woman involved supposedly was having a conversation with like a girlfriend about it afterwards. So, and it was conversations about, which I don't know. I mean, but it was about the encounters with him. So I don't know if those particularly would give rise to a privacy claim. But I mean, that could still support the the defamation claim. Oh, someone in the chat, Ben I says, I always look at the URL. Interesting. Okay. So, maybe I'm just an outlier. So, I don't know. Maybe I'm an outlier. How many of you guys, how about this? How about people in the chat? If you read the URL, type a 1. And if you don't read the URL, type a 2 in the chat. Just to like see visually, like maybe I'm the outlier. I don't know. I could be. So we'll see that. We'll see that coming up. So, all right. People are starting to say, okay, mostly 1s, 1.5. Okay. I mean, I guess more people read the URL.
Okay. Fair
Interesting.
enough.
Interesting. Right. Okay. All right. And thanks, Dragon's Treasure. Why is no one super chatting? Give some money. I appreciate that. Thank you. It's because they're so engrossed in this particular complaint and in this conversation. So, okay. Interesting though. Yeah, I'm not particularly thrilled about the alleged screenshots, but I don't know. I that's not enough to like really, I don't know, make me upset about this. You know what I mean? I don't know. If it happens multiple times, maybe. We'll see. We'll keep reading. All right. The defamatory allegations of sexual assault and forcible are leveled against Mr. Portnoy are patently absurd and provably false. While the first story is replete with false and defamatory lies about Mr. Portnoy, the references to his alleged encounters with 2 women, referred to therein as Allison and Madison, are partly egregious and defamatory per se. Okay, so that means that they are alleging some kind of criminal misconduct here. Okay, so then we get to the portion that's called Allison. There's 2 portions here. Yeah, the other one's going to be Madison. So yeah, you can see here that we're gonna get to some screenshots here. He's going to share. Okay, Allison, paragraph 25 on page 9. And I'm also going to link to his article where he publishes this in the I'm gonna post the link to his article where he publishes the complaint in the description below. I meant to do that ahead of time. I'll do that afterwards. Okay. Paragraph 25. Defendants dedicate a significant portion of the defamatory first story to an entirely fabricated account of Mr. Portnoy's alleged encounter with a woman referred to in the first story by the pseudonym Allison. In short, defendants falsely reported that after a violent and impliedly non-consensual sexual encounter with Mr. Portnoy, Allison suffered from severe depression and suicidal thoughts, which allegedly resulted in her seeking treatment at the hospital. As defendants were well aware prior to the first story's publication, Allison's account is pure fiction.
I really hope they're going to go into detail about how they were well aware, or I'm going to be a very sad panda.
Yes. Yeah, because any time that they have a any kind of information that would be reasonable for someone to rely on, that's all they have to show, and they can get away from liability. So, for example, when we were talking about the Kyle Rittenhouse case, anyone that was repeating the claims that were made by the Kenosha County DA about him, he was crossing state lines, and it was illegal for him to hold that firearm. Anyone that was making those statements, at least leading up to the trial, they could reasonably rely on the charges that were filed by the DA. So it's like,
I've taken the position to the displeasure of my chat that Kyle's ability to sue for defamation anytime prior to the trial ending is essentially non-existent. There might be something, but it's going to be really hard. Maybe since the trial ended, which there might be a few statements, but yeah.
Agreed. Hey, 2012 Jameson, thank you so much for your super chat. He says, since it was behind a paywall, to some people that might construe it to be the full story. I do agree. I do agree. So, all right. going back to the complaint, according to the first story in July 2020, Allison messaged Mr. Portnoy notifying him that she was in Nantucket and, quote, would love to see him, unquote. Allison met Portnoy at his home where they spent the day by the pool. According to defendants, Portnoy and Allison then began having violent relations with the implication that the encounter was not consensual. Okay. And then it's going to quote directly from the article. Quote, he leaned in and started kissing me, and I didn't know what to do at that point. Ellipses. And we went upstairs, and he was really aggressive, and I didn't know what to do, and we had sex, and he kicked me out. Ellipses. She said Portnoy choked her. Quote, he kept spitting in my mouth, which was really gross. I was kind of scared. I didn't want to disappoint him, unquote. And that's the end of the paragraph taken from the article, I guess. Interesting.
And then the next line doesn't quite follow for my money. Insider implied the encounter was not consensual. I don't know by its own terms that it implies that. It seems to be that she was going along with it. Now, in her own head, maybe she wasn't liking it, but how would he know that? She says, I didn't want to disappoint him, which sounds like she was going along and not. Does that imply lack of consent? I mean, how would you read it? Maybe.
I mean, if this were an actual, if this were a case where she claimed sexual assault against him, like she filed a claim against him, I would say, yes, this does not suggest that there was a lack of consent, because as uncomfortable as she says she was after the fact, she's not saying or doing anything that shows that she's not consenting. And it doesn't appear from, at least, that this may be taken out of context. So assuming that there's no alcohol involved, there's no substance abuse involved, she's got a clear mind and she can fully say what she's thinking and whatnot. Then I mean, yeah, there's nothing here to suggest that there is a lack of consent. But I understand Portnoy's point here in the context of the Me Too movement, because there are many people today who, let's say Aziz Ansari, for example, the story that was published about him.
Man, that one pissed me off so much, because I read that story and I was like, why are we crucifying this guy? He did nothing wrong.
Yeah.
That one pissed me off so much. How are we Me-tooing that guy?
I had disagreements with some girlfriends of mine who were like, yep, he deserves to be canceled. And I was
how did your girlfriends think that he did anything wrong by the story's own terms? Can you explain to me? Because it didn't make any sense.
And let me just say this. I have friends all over the political spectrum. Okay. Because I love being able to have friends and have tough conversations with my friends, regardless of the topic. And I always want to try to keep those kinds of friends, because, it helps me to understand my own thoughts, my own worldview. I personally think that Aziz Ansari got screwed by the Me Too movement. I'll just say it. I think he did, because when I read that article, I was like looking for the lack of consent in that situation. Yeah. I was like, okay, so she says she didn't want to do it, but she didn't say anything. Like we said earlier.
Yeah. So how
the law says?
I mean, if you don't want to talk about it because it's off topic, that's fine. You can ignore me.
No, I mean it's all kind of, it's all kind of in context.
Friends or your girlfriends think that he should be canceled because of that story? What did they see that I failed to see?
I think it had. I can't remember, because it's been a while, right? Because it was right around the time that the article came out, but. I think it had to do with a power dynamic, with him being a famous person and a very wealthy person, and her being some woman. I don't buy that personally. I don't buy that at all.
So if people say power dynamic, here's my next logical question. Is it permissible for a woman to consent to sex with a man who's in a more powerful position? Is that an okay decision for her to make or not? Should she be allowed to make that decision to sleep with a more powerful man? Yes or no? If the answer is yes, what are we talking about?
Yeah.
So it's okay for her, but not okay for him? How does that make any sense?
Right. It's so, Yeah, there has to be some indication, unless she is, if she's passed out drunk and she cannot consent.
Yes, no,
that's one thing.
I'm on board with you in alternate hypotheticals.
Yeah,
I'm
but
not
if we are
disputing
talking
alternate
about,
hypotheticals.
if we're talking about, people who are otherwise, like they'd be able to sign a contract and have it be enforceable. If she doesn't say that she doesn't want it, then that's on her.
Yeah,
that is on her. That's where the law stands on that. And some women don't like that because they don't want to have to say that they don't want something in a moment.
How am I supposed to know what's going on in your head subjectively?
Absolutely.
How is that a thing that anyone is reasonably supposed to know?
Yes. Yeah.
This is insanity. Your friends are dumb. Let's move on.
Well, I love them. We happen to disagree on this particular issue, or at least we did when we last talked about it a while ago. Wisco Casey, thank you so much for your super chat. Says, thanks for covering this. I'm greatly looking forward to how this plays out. #Viva. Yes, I agree. I'm very interested in how this plays out as well. So okay. So, but back to how Aziz Ansari sort of fits into this context with Dave Portnoy. I think that his point here is that in the world post Me Too movement, or during the Me Too movement, you could even say, this is something where you could post an article like this and you can cancel somebody. And if there's non-truths in it, you've got some lies in it, regardless of whether or not there actually would be a crime that would be committed. I don't think that matters. I think it's the perception of whether or not that's criminal to your average person, because you and I know that there has to be some element of consent, right? That if she is going on with this, as he's aggressively choking her or whatnot, there are people who consent to that kind of thing. There are people that have all kinds of different flavors of what they like to do, and that is up to them. And I'm not going to shame anybody. This is just, everybody gets their kicks in some way. And that's how he gets his kicks. Maybe she does too. She doesn't say anything that says otherwise. So, you and I know that that is a situation that doesn't appear to lack consent. But your average reader of Insider, who knows?
They're dumb, but that's yeah. Yeah, maybe that is a factor that should be considered into the equation, because we're talking about, reasonably prudent person is normally our go-to, but maybe it's the reasonably prudent person who reads Insider, in which case whole different legal standards, maybe.
I mean, I don't know. I mean, I think it probably would be more like the reasonably prudent person, but I don't think that you necessarily need to have a reasonably prudent person wouldn't necessarily know the nuances of this area of law. Although, I mean, it would be very helpful for a lot of people, I think, because this is like something that really affects most people, these kinds of relationships, not these specifically, but, a lot of people do a lot of stuff, so where somebody consents or doesn't consent is something that does affect a lot of people. So anyhow, but I think that the perception that he's maybe engaging in behavior that is criminal is, I think, what's important. More important than whether or not the actual facts as are laid out here would actually give rise to a criminal liability, if that makes sense.
Doesn't sound like it.
Yeah. It doesn't sound to me like there would actually be criminal liability in that, but like I said, I don't think that matters. I don't think we even need to get that far. I think we need to just show that that there's that your average person would have that impression that something criminal is going on here.
And also, as to invasion of privacy, it's not an invasion of privacy for her to talk about her experience. She was there. She has the right to reveal her own, stuff.
True.
Even though that speaks to his privacy interests, it's also her privacy interests. They share it, and she can expose her own impressions of the experience. I mean, in a truthful way, but opinions, I mean, I mean, okay. I'm still waiting for the big reveal of how they knew that this was false, though, because that's kind of the most important thing for me in this right now. Because if he says that they had clear evidence or knew, if he doesn't make that clear, I'm going to dismiss this lawsuit without breaking a sweat. So I just want to know. That's where I'm kind of looking for at the moment.
Okay. All right. So, okay, let's read on then. Insider implied that Allison's encounter with Mr. Portnoy was not consensual and so impermissibly violent as to constitute a sexual assault. Defendants went on to state that Allison, excuse me, was so distressed by the events that she could barely talk the next day. Defendants further reported that Allison was hospitalized and became suicidal due to the allegedly violent sexual encounter. Moreover, defendants published that Allison's mother reported Mr. Portnoy to the Nantucket Police Department and falsely suggested that he was under criminal investigation for sexual assault. Prior to publication, however, defendants were in possession of the so-called police report, which highlights the outrageous nature of the allegations that Allison's mother made against Mr. Portnoy, namely that he was often seen in public with younger women. Defendants failed to include these facts from police report. I think it's supposed to say from the police report in their first story. And for good reason. The police report does not accuse Mr. Portnoy of any criminal conduct whatsoever. So, I was thinking of something earlier, Kurt, when you said that the woman that he had an encounter with, she has a right to talk about that. I think I do agree. However, the question here is whether or not Insider has a right to publish that information.
I think so.
Yeah. So the question is not so much about her sharing her encounters with friends and with, reporters at Insider. But
if she has the right to talk to her friends about it, she's publishing to a third party. So what difference does it make?
Right.
Other than the scale of the thing, but that's not a factor in the law.
And I think that that's why she's probably not a defendant in this lawsuit. Because at least as to the invasion of privacy claims, I don't think that he would be able to sue her for that, because it's also her privacy at the same time. And so she would have just as much a right to publish that kind of stuff as he would. So, but the question is not about her, it's about Insider. Cherokee Girl, thank you for the super chat. It says Indies fee and Viva la Barstool. Thank you. I appreciate it. Okay. So this thing about the police report is interesting. So it sounds like it's not saying that there wasn't a police report that was filed, but it's more so about whether or not the police report went anywhere and whether he was even being investigated by the police at the time that the article was going on.
There's also something called, when we want to privilege, by the way, talking to that last factor about whether communications are privileged, there is a privilege that potentially applies here. It's the fair report privilege, which applies to government documents. If there's a work of the government, as long as you're fairly reporting on that work, you can't be held liable, even if the underlying thing is libel. So the police report is a work of the government because they're the one creating it. So the fair report privilege might apply, and that might be a privileged context as well as to the police report.
Okay. That makes sense. But I think that their representation of what was going on with that report could be where they're stepping outside of that document.
Yeah. So it might not be a fair report. Yeah.
Right. Exactly. So them saying that he's being investigated by the by the police. Good Lord, my voice.
Maybe you should put some honey in that tea or something.
I know, right? I need more tea. So the fact that they're saying that he's being investigated by the police for that report, that seems to be going outside of it, because if he says that, that it's clear to anyone that he's not actually being actively investigated at that point.
I don't know how they would know that from the police report or not. The police choose to investigate things or not for all kinds of reasons. So I don't know. I mean, even if the report by its own terms doesn't necessarily imply, by its own terms, suggest criminal conduct, it might to the police officer suggest a line of inquiry that, maybe they see something that raises a question in their mind and they investigate on the question rather than, so I don't know that you can necessarily conclude from the police report that they aren't investigating, but
Okay. Yeah. No, that's fair. That's fair.
Also, what does it mean to investigate is a bit open. I mean, they thought about it for a half second, even if they decide not to. So,
okay. Secret Squirrel, thanks for the super chat. He says, towards some honey. Thank you. I appreciate it. I will have to add some honey next time to my tea. But so far,
grab some honey real quick. I'll try to vamp for a while.
No, I think I'm okay now. I'm okay now, but I will probably bring honey with me on the next stream when I have tea. I love this is like turning into a beautiful little tea party with like multiple kinds of teas.
This is the strangest tea party ever.
I know. Yes.
We're spilling some tea. We got that going for us.
It was spilling tea in more than one way. Before you got here, I spilled it like all over my desk when I was like pouring it out. So that was fun. Anyhow, but so I finished the uwu and I really like it. And I also really, really like this Sebastian's Morning Earl Grey Vanilla Cream. Really, really good. So far, 2 thumbs up on these wonderful teas. Okay. Back to spilling the other kind of tea. Okay, let's move on with this complaint. Okay. The allegations concerning Allison are false and belied by documentary evidence in defendant's possession. Indeed, defendants had all of Allison's communications with Mr. Portnoy prior to and after her alleged encounter with him. Further, defendants were in possession of the police report filed by Allison's mother, which critically contained no allegations of rape, sexual assault, or any other crime for that matter. Even a cursory review of the police report and Allison's subsequent communications with Mr. Portnoy revealed that her story was entirely fabricated. Defendants published it anyway. Okay, so I mean, I'm assuming at some point we'll see that the police report. I don't know if it's going to be in. Actually, no. I'm pretty sure it's not in this. It's not in this complaint because he has 2 exhibits that he attaches, and they're both articles that were published by Insider. So if you guys want to read it without the paywall, you can see it as exhibits to the complaint. Sorry, were you going to say something?
No.
Oh, okay. All right. So interesting. Yeah, and again, I want to know about these communications between Allison and Mr. Portnoy. Pushing on. The day before she visited Mr. Portnoy, Allison begged him to let her come to his house. Quote, "I'm on an island with all my friends and really want to see you. Would do anything. Let's hang tonight." Unquote. When Mr. Portnoy stated he was unavailable, Allison stated, quote, "No, it's your last week in Nantucket," unquote. The following day, Allison messaged Mr. Portnoy again and stated that she wanted to have sex with him. Quote, "What you doing today? Can we bang?" Unquote. And then they attach some screenshots or a screenshot here of exactly that conversation ostensibly between the 2 of them. So it doesn't, that the profile pictures appear to be blurred out and it doesn't have a name. And I think that's just for confidentiality purposes. But also maybe they're real, maybe they're not. But for the purposes of analyzing a complaint, we're going to assume that they are real. All right, moving on. Allison and Mr. Portnoy made plans to see each other that day. Just prior to arriving at Mr. Portnoy's house, he texted her, quote, "Don't be nervous. It'll be fun. And if you don't want to do anything, we won't," unquote. Okay. That doesn't necessarily mean that those things didn't happen later on, but we'll keep reading. After spending time at the pool, Mr. Portnoy and Allison had consensual sex in his home. Critically, after Allison was allegedly in the hospital and suicidal due to her encounter with Mr. Portnoy, she continued to contact him via text message and Instagram. None of her messages indicated that she was in any distress. In fact, Allison sought to continue her relationship with Mr. Portnoy. That seems suggestive of somebody that probably had a
What was the day of this alleged assault?
It doesn't say. I think it's in the summer sometime. I can't remember.
I'm just trying to get the timeline right.
Yeah, it's at some point in the summer. I can't remember exactly when. So, okay. All right. So, in fact, Allison sought to continue her relationship with Mr. Portnoy. So, if the text messages suggest that, then, I mean, that's point Portnoy right there. If the text messages do suggest that, because this is something like the text messages leading up to it don't necessarily indicate anything about what followed afterwards.
Right.
They indicate what could have followed, but the text messages afterwards give a hint as to her state of mind and her impression of what had happened.
Correct.
So the fact that she wants to continue having a relationship, apparently, according to text messages, and that she wants to have more encounters with him, that would imply that if she didn't say anything during it, then it seems like her not saying anything and then sending text messages to him saying that she wants more seems to suggest consent. What do you think, Kurt?
Yeah, I think that's suggestive. Yes. Yeah. I'm hoping there's a little bit more than this as to actual malice. But we'll keep reading on.
Okay. On August 1st, 2020, Allison replied to Mr. Portnoy's Instagram story in which he announced he was leaving Nantucket to spend the summer in the Hamptons. Allison stated, quote, "Aw, bye, sad face. Nantucket is better," unquote. After Mr. Portnoy responded to her unsolicited message, Allison replied, quote, "I'm in shock that you're still direct messaging me right now. Like, what's up, Dave Portnoy?" unquote. The next day, on August 2nd, 2020, Allison messaged Mr. Portnoy again, stating, quote, "If you ever want to text me, my number is," and then it's redacted, unquote. As is clear by the evidence in defendant's possession, after Allison was purportedly hospitalized due to Mr. Portnoy's alleged conduct, she repeatedly contacted Mr. Portnoy in hopes of seeing him again, gave Portnoy her phone number, and encouraged him to continue their relationship. Defendants were in possession of these messages prior to the first story's publication, yet defendants included Allison's false allegations in the first story anyway. What do you think about that, Kurt?
I'm not sold.
Okay. All right.
I'm not sold because one of the things that and I assume this hospital report does in fact exist, because we're not saying it doesn't exist.
Yeah.
So
because he also,
interestingly,
he didn't say that it was
publishes had the hospital report, which is a thing day after, and would presumably detail, assuming this assault occurred, then presumably the hospital report would reflect all that, and that would be a reason to think it did occur. These statements to him are suggestive as well, but they could be they could be understood a whole bunch of different ways. For like they were trying to get him alone so she could get him on tape confessing to the thing or whatever, or it could be a bunch of things. But if they have excuse me, if they have a police report and they have a hospital report, then I'm not sure that these text messages are enough to get you past the actual malice threshold, because actual malice is pretty hard. Yeah. So I'm not sold.
Yeah. Okay.
But if you disagree with me, feel free to say.
Yeah, I mean, you're right about the hospital report, right? Because I was going to say earlier that it doesn't say here, that she was allegedly in the hospital or she was purportedly in the hospital. It looks like Portnoy is basically conceding that to that fact that yes, she was in the hospital afterwards.
Yeah.
So because that was something that I noticed. I didn't point out as we were reading, but I did think that it was interesting that he didn't say she allegedly went to the hospital. So it seems like that's a fact that everyone is going to kind of agree on. So that
So if that hospital report has evidence of things that would reflect a particularly violent sexual episode, whether consensual or not. And then she's saying, I felt a particular way about it. And here's some evidence the encounter did occur, which he's conceding to, incidentally. Then I'm not necessarily sure I buy defamation. I'm not even sure I necessarily buy it's false, because everything she said doesn't seem to be. I mean, she's talking about her own subjective impressions. I'm having problems getting a defamation on her.
Well, so we're reading this story as told by him.
Yeah. I mean, there's a fair factor to so yeah, but this is part of the problem. It's exactly that is making me skeptical. This is written by him in his light. We should assume this is the best possible way to describe what happened that would lead to the conclusion he wants to do. This should be the best version of the story that would lead to it. So when I'm spotting problems, so I'm kind of reading this complaint against him for exactly that reason. It's like, I'm seeing some holes here. And I mean, this is a problem.
Yeah.
If you can't make it any better than this, I'm having some problems on this complaint. Yeah.
I think so. I think that it's not exactly the smoking gun that I think Portnoy wants it to be. But I do think that so far I see enough for this to get past a motion to dismiss.
Maybe you're a more generous judge than me.
I mean, it's such a low bar for someone to pass, because if we're kind of like analyzing like, oh, okay, but like, you know, they have the hospital report, they have the police report, they have her, you know, copies of her DMs to him, you know, like, in their conversations afterwards, you know, like they have all of these things together, you know, like you're starting to weigh pieces of evidence against one another. You're getting into a gray area. Whereas when you're analyzing a complaint for whether or not it's going to survive a motion to dismiss, you have to see black and white. If things are not black and white, you start to see gray, then it's probably going to survive. If that makes sense. Because like the judge is not going to be weighing different pieces of evidence.
I mean, you're weighing it to a very low standard, but yeah.
The judge is going to assume that the facts as drafted in this particular complaint, the judge is going to assume that all of these facts are true.
Yes, but I'm just anticipating what the response is looking like. I would imagine the response is going to talk a lot more about the hospital report, probably include the hospital report, probably include the police report. And those are now elements that are there. And so one of the questions I'd be asking as a judge, among other questions, first of all, is there a false statement of fact, which isn't necessarily obvious? And then, even assuming that's true, with reckless disregard, if he had this, if the people had this stuff in addition to this, it's like, is there enough to get you past the threshold for a lawsuit? And maybe I'm a bit stricter, but I'm not convinced the answer is yes. I understand your reasoning. I get it, but maybe I'm not doing the right thing by weighing it a little bit more than I should. But that's, you know, I think that's what I would do. So maybe we just would slightly disagree on this issue, but it's fine.
Yeah.
We can criticize each other in our respective opinions.
Oh, of course. Logan Cisco, thanks for the super chat. He says, to be clear for Stooley's in the chat, this isn't Kurt's personal opinion, just objective legal opinion of a document. Right. Absolutely. Correct. Right. Because what we're analyzing here is this complaint drafted well enough so that it can survive a particular standard. So, you know, whether or not things happened the way that Portnoy says that they happened is completely different than whether or not this survives a motion to dismiss. So, and that's what we're kind of analyzing this for, is like does this not only survive that kind of standard, but then also, you know, after it gets to that point, is this the kind of case that is going to do well or not so well if it goes all the way to trial. John O'Brien says, Kurt, you're wrong about motions to dismiss. You're applying motion for summary judgment standards.
Yeah, I mean, there is definitely a distinction to be made between the two. And at least to my mind, in a motion to dismiss, you have to have, it has to be plausible. It has to have some merit to it, that accepting everything is true, a jury could come to this conclusion. Mm-hmm. But there's some obvious holes here in the thing, and I'm like,
I think what you're doing at this point is actually analyzing the merits of the case itself, which is beyond a motion to dismiss question.
Okay, fair enough. I maybe I am, and if so, then one of the reasons I love these streams is because I can be wrong, and I don't mind being checked by a fellow attorney who has a reasoned, thoughtful opinion. And it's like, I think maybe you're doing the wrong thing, and I appreciate that, Legalbytes. So thank you. I'll reconsider whether or not I'm properly applying the motion to dismiss standard as we continue on.
No problem. And maybe I'm wrong, but I don't think I am.
No, I appreciate that.
And thanks to John, because I think John is also an attorney, I think, down in Florida. So I believe John also knows
Chris and Error. I mean, like, geez, Lord. Chris and Error says Kurt hates when he's wrong. No, he doesn't. Kurt doesn't hate when he's wrong.
No,
he's like, geez, well, you've been pushing back a little while now, and you've given me something new to consider, and I might be in error, and I appreciate you mentioning it because it lets me be less. How is that me hating being wrong? It's like, maybe I've made a mistake. Maybe I should reconsider my position. What do you want from me?
Yeah. So for the record, for anybody watching, Kurt, I mean, it's not that you enjoy being wrong, but you more than anything enjoy arriving at the truth.
Yes.
And arriving at the actual answer. So whether that, whether that comes through conversation on streams or through your own research, off camera, then, that doesn't make a difference to you. So that's the distinction. And I agree. I mean, I'm wrong about stuff, and I'm corrected by people all the time. So, someone said Nick Rekieta said he's never wrong. Nick Rekieta is wrong sometimes. Love him to pieces, and he's wonderful, but everybody's wrong at some point. So let's get back to this complaint. We'll finish off this Allison section. So it says, further, despite the police report did not contain any accusations that Mr. Portnoy committed a crime, defendants included references to the police report in the first story, falsely implying that Mr. Portnoy was under criminal investigation for sexual assault. Mr. Portnoy was not the only person shocked by the allegations of criminal conduct. Indeed, on November 5th, 2021, in response to the first story's allegations concerning the police report, Nantucket Police spokesman Lieutenant Angus McVicker issued a statement to NBC News clarifying that Portnoy was not under any criminal investigation whatsoever. So I think it depends on how the article referenced the police report. I think that's part of it too. Like we're reading his allegations about the article, but we're not actually reading the article itself. And I don't know if we're going to have time to go through the article itself, but that's one reason why I think that it'll be good to link to this complaint in the description. So if anybody does want to read it, they can read it. I think both of the articles, because they're added as exhibits at the end of this complaint. Okay, now into the section called Madison. So we're still in the first article that Insider wrote, but this is about the second encounter that they talk about, which is about a girl with a pseudonym, or a woman, I should say, with the pseudonym Madison. Defendant's smear campaign did not stop there. Additionally, the first story described Mr. Portnoy's alleged encounter with a woman referred to by the pseudonym Madison, wherein Mr. Portnoy is falsely accused of sexual assault and forcible, I've started saying it, rape. Such allegations are equally preposterous. Defendants reported that Madison traveled to visit Mr. Portnoy at his home in Nantucket. Prior to visiting Mr. Portnoy, Madison messaged Portnoy for several weeks, wherein she described to Mr. Portnoy her quote-unquote rape fantasy. And this is where, No shaming anyone for what they do with consent in the bedroom. But these kind of fantasies, they get, when people act out these kind of fantasies, things get a little bit tricky, right? Because you have to have people really, really understanding one another in order to play something like this
out. Bare minimum, I'm telling you what.
I think so. I really think so. And I think having that kind of encounter with someone that you don't know for a long period of time and like really have a lot of trust with, I mean, it's just, I think it opens up a lot of risk for both people, right? Like for because either person can be really really taken advantage of in this kind of a situation. Let me get the super chat real quick. Ruby C, thank you so much. Kurt, I would like you to explain why people spit in each other's person's mouths. That's what I want you to do. You don't have to
explain a lot of what people do, but people do a lot of things, and that's all I can say really about that.
That's all I have to say about that. Yeah, I don't, I mean, that would require a certain amount of, I don't know, human psychology. And for anyone that is just joining us, the reason why that super chat says that is because that's an allegation that we already covered. So anyway, okay, let's move on. Defendants went on to describe an entirely fabricated series of events, namely that Portnoy choked and raped Madison. Okay, we're getting to another block quote here from the article. Quote, "It was so rough, I felt like I was being raped. It hurt, and I was literally screaming in pain," she recalled, crying and shouting, too much, and it hurts. I kept trying to get away, and he was like, stop running away from me, stop running away from me. So if this is in the context of acting out a particular fantasy that involves...
this is where it gets tricky.
It gets very tricky. It gets very, very tricky. So... But I understand people reading a statement like this and thinking that something criminal was going on. Right?
Yep.
So and by the way, like when he's including these portions from the article, he's not necessarily saying that this is the way that it happened. What he's saying is he had an encounter with them, and this is what was written up about those encounters afterwards. So that's another point that we can sort of distinguish here from from the article, so to speak. So he's not necessarily saying that this is what happened. He's saying that this is what was written about it. After the purported rape, defendants reported that Madison slept on the couch for 2 additional nights before flying back home. That is interesting. He doesn't say whether that's true or false. Well, now he says the allegations concerning Madison are provably false. In reality, Portnoy and Madison engaged in consensual sex, and defendants were fully aware of that fact. Indeed, prior to publishing the first story, defendants were or should have been in possession of all of Madison's communications with Portnoy, as well as her social media posts. Well, were or should have been in possession. I don't know that I particularly like
should have been. It's not doing anything for me.
Yeah. Because I mean, to take a story about a famous person, you don't necessarily need to say, okay, I need to see all of your communications with this person in order to meet the reasonable standard of, like, a reasonable standard could listen to what this woman is saying, have a little bit of corroboration, to say like, oh yeah, he flew me out there. Here's the receipts, for my tickets out there. So that the should have been is not particularly great, but if they actually did have them, okay. So as well as her social media posts. Okay. Moreover, it is beyond dispute that as of November 11th, 2021, when Portnoy publicly disclosed those communications while taking steps to conceal his accuser's identity, defendants have been in possession of Allison's social media correspondence, yet continue to refuse to retract, correct, update, or in any way modify their defamatory first story. So that's something. Because a defamation can be ongoing as well. Because if somebody publishes something with, you know, reason to believe that everything that they've published is true and correct, but then certain pieces of evidence are brought in that would show that those are not true, and they say, well, doesn't matter, we're gonna keep it up. The continuing to keep it up could be the start of the defamation. What do you say, Kurt?
I would tend to disagree. You normally need some kind of republication. Merely keeping up an initial publication is what you said and what you knew on the day that you said it. So I don't think that new information that comes to light after the fact would change whether it was defamatory or not on the day that you published it. If it was republished, yes. If it was just published, no. So I would disagree.
I see, the reason why I say that is because there's continuing access for more people to see what's written. Like, it's not like if it could, because publication could be somebody making a statement on TV, for example. That could be that's a publication. But if they go and they post, you know, like a video of them, you know, saying the same thing, and they post it somewhere publicly on YouTube or wherever, and they refuse to take it down.
All right, let me give you a hypothetical and see if it changes your mind.
Okay.
Assume someone writes a book that on the day it was published would not be defamatory under the law for reasons, you know, that okay, so after this book is published and it's distributed and sold and, you know, in libraries and all the rest of it, some point after that, new information comes to light which shows that, yeah, this is totally just garbage. It's all crap. Is there an obligation for that book author or that book publisher to recall the book, write a new edition, publish a new book? Is there some obligation at that point? Because, I mean, the book is on people's shelves. They can read it anytime. Is that different?
I think that is different because you have a lack of control. Whereas when you have an article on a particular website by that specific publisher, they have complete control over that article as it appears on their website. They wouldn't necessarily have control over people, you know, copy pasting and saving as a PDF, because that, you know, if somebody else decides to republish it elsewhere, then I think that they wouldn't be liable for that necessarily. But I think that if they have the ability, you know, like that's very different. An article on a website is very different because it takes far fewer resources to change or update an article as it does for a particular book, for example, because you would have to, as you said, you would have to recall books, you would have to do all that kind of stuff. But at the same time, even with a book, if you have a second edition to it.
Yes, if you had a second edition, yes, you would. Then that would be a republication. I'm on board with you if there's a second edition. But here, I can see the point that it's obviously much easier to modify a website. I mean, that's obvious. It's easier, it's cheaper, it's more practical. But does that change the actual legal analysis? Because I can, I must. I mean, that you know, I mean, I could theoretically, you know, publish a new book. I could theoretically publish a pamphlet. I could theoretically do a whole bunch of things to correct this false book. I mean, it would be harder, it'd be more expensive, but I could. Let's even assume I have the money to do it. Let's assume that money isn't a factor in this equation.
Yeah.
So I could, you know, without it being a problem, you know, publish a new edition, publish a correction, publish a whole bunch of things. It's a lot easier for a website. Does the fact it's easier mean I'm suddenly obligated to where I wasn't before?
Well, I think what it comes down to is the definition of publishing. So at what point have you published the book already? And at what point have you published the article already?
Well, I think as to that, that's just an issue of fact. And we can assume the article was, I mean, the publication would be the first time it was made available. That would be the publication date. If it was altered, then at some point you could argue republication for any alterations. So the last publication date would be the last time the article was edited or changed. That'd be the last publication date. In my view.
Yeah, I don't know. I mean, I do think that there probably is a factor there of the ease with which that article, that publication can be modified. Because I think that, if like you can see this in a lot of different areas of law, right? Where you could say, okay, technically, yeah, there's a continuing problem here with this getting out there, but are we really going to expect people to pull books off of shelves, eat all kinds of costs, all that kind of stuff? Like there's a certain fairness and expense kind of element that courts will also impose into the fact pattern. And I think that here, where we are talking about an article on the internet, where it's relatively easy to add an update to it and say, okay, we've recently gotten information from, source XYZ that what we were saying is not correct, or
is it
perhaps
the same,
not correct.
Is it the same for a podcast or for our YouTube shows? Is it the same there? Because we could delete the old episode or upload a corrected episode or something like that, or is it only when it was originally made available that matters?
You can update the description. You can pin a comment.
Yeah,
that would modify.
Yeah,
I would say. Yeah.
I don't know. I think that I think as a matter of law that the date of publication is the thing that matters, and the fact that more people can access it in the future, I don't see it unless there's some specific law on point that I'm unaware of. I don't see it.
All righty. 2012 Jameson, can you have Nate cover the case of the naked NFL player trying to tackle the officer in California? I haven't heard about that one. You might want to ask Nate about that. I don't know. I don't know if he's seen that case or not. John O'Brien says Google single publication rule with Kurt on this. Okay. Well, maybe I'm wrong on this one. So I could be wrong. So, all right, let's continue.
We all learn something.
I know, right? We're all wrong from time to time. Okay, Madison operates a, quote, Finsta account, slang for fake Insta, a term used to describe secondary Instagram accounts where the user's identity and often the content of the user's posts is unknown to all but a small, carefully chosen group of followers. The posts on Madison's Finsta account unambiguously contradict defendant's false report. On July 19th, 2020, Madison uploaded a picture of her and Mr. Portnoy playing Scrabble together. The photograph depicts Madison and Mr. Portnoy together in Nantucket on the weekend of the alleged sexual assault. In the post, Madison gloated, quote, me beating Dave Portnoy in Scrabble, unquote. On July 20th, 2020, the next day, after having consensual sex with Mr. Portnoy, Madison then posted a video to her Finsta account revealing her true motivations with Mr. Portnoy. In the caption to the video, Madison wrote, Portnoy was a D and lame and grumpy. He gets a 2 out of 10 from me. If he ever truly pisses me off, I have lots of content to expose him with. I'm going to stick to athletes. And then it has little dollar bill with wings emojis following after that. Interesting. Later, Madison posted a picture of Mr. Portnoy with Donald Trump. In the caption to the photograph, Madison wrote, okay, not my proudest F. Notably, in the days following the first story's publication, Madison sought to take advantage of her newfound notoriety by setting up an OnlyFans account, an online platform whereby the general public can pay Madison for personalized content, photos, videos, and live streams via a monthly subscription membership. Oh boy. Okay, that's interesting. Doesn't necessarily mean that it wasn't consensual. So I will say that. But the Finsta account stuff is pretty interesting. I don't know, Kurt, what do you think about that?
I mean, they are all potential statements that show credibility issues for sure. Yeah. A very real question still is, did the people who published the article have access to this? Because I don't think
would
that
they
was
have
made
known
clear.
Would they have known that she had this?
Yeah, because by their own terms, Finsta accounts, as you read the paragraph, are more secretive. So unless they knew about all this stuff, then it doesn't factor into their decision making.
Right. Exactly. So we need to see that they somehow knew about it, that he knew about it at the time and he told them about it, or somehow elsewhere that they knew about it. Okay. Continuing on, despite the fact that defendants had access to Madison's social media and should have been fully aware of the problems with her false and sensationalistic account of events, defendants published the defamatory first story anyway. So he says that they had access to her social media, and we do have to accept his factual allegations as true.
No, so they had access to is, I think, very cleverly worded, because yes, they had access in so much as anyone could go into Instagram and theoretically find their account. So yeah, they had access to it, but whether they accessed it or whether they knew about it is, in my view, a different question. I think they're just being very clever in their wording. All of you have access to all my videos. Does that mean that you're suddenly on the hook for knowing every single one of my videos? Yeah. I don't even know every single one of my videos.
Yeah, that's fair. Should have been fully aware of the problems with her false and sensationalistic account of events. Yeah, no, that's true. I mean, it would have been better. It would have been stronger if this alleged they knew of this account. They knew of this account.
Yes.
And they
had access as weak sauce. I think they're being tricky.
Yeah. Yeah, I think that. Yeah, and the whole should have been fully aware is not as strong as if it had said, and that they were fully aware of the problems with their false and sensationalistic account of events. All right, on November 11th, 2021, after taking steps to protect the anonymity of the two women who purportedly accused Mr. Portnoy of sexual assault, Mr. Portnoy published redacted versions of Madison's Finsta posts to all of his social media accounts. Despite having access to this information, defendants have failed to and refused to retract, correct, update, or in any way modify their defamatory first story.
Yep.
Okay.
I don't think it matters.
All right. You're probably right about that. Yeah. I think. Yeah. Okay. Critically, Mr. Portnoy provided defendants with the true facts and documentation concerning Allison and Madison, including through Mr. Portnoy's various press conferences, which Insider admits it viewed.
After the fact.
But Insider ignored the information because of their preconceived agenda to harm Mr. Portnoy's reputation. In particular, Insider was made aware that critical text messages were available to them, but Insider did not demand them. Where Insider did include information from Mr. Portnoy, Insider made an affirmative effort in its presentation to minimize its report. Yeah, it's
I am not sold on any of this.
Yeah, his giving the information after they already published doesn't particularly help them. Let me get a couple super chats here. Old Man Hawk says, what about Google search results that might push the article with bad information to the top constantly? I don't think that's a factor here. No. Because we're not suing Google. We're suing Insider here.
Correct.
John O'Brien says he knew or should have known the letter's the hook. Oh, that's That's fair, because it's when we're talking about actual malice, he has to allege that that insider knew or should have known that what they were saying was false.
They have to show that they knew or recklessly disregarded. So should have known
recklessly
is reckless
disregarded.
Disregard.
Yeah. Although I think that there's a reasonability element that's introduced in there too, though.
Nate was calling me.
Your neighbor?
No, Nate.
Oh, Nate. Oh, hey, Nate. You should put him on speakerphone. I'm just kidding. Don't do that. So I think it's actually reasonably should have known, because it's to just say that somebody should have known that something existed. Is not enough. It still has to be a reasonable person. So even if they just have a reasonable belief that what they're saying is true, and that a reasonable person would a reasonable person would have relied on that, then that's enough for insider to be safe. Okay.
It's too conclusory for my mind. It's too conclusory to say no or should have known. You need to show me a reason that they should have known. I don't. Mere conclusory statements are not going to persuade me. I don't buy that.
Yeah, but this still, I mean, the standard really is that low, though. It really is that low. That I still think that there are enough facts that are alleged here that this gets past a motion to dismiss. Hey, Nate. He says, I see you, Kurt. Nate, do you want to join us? I can send you a link.
Yeah, we're having some disagreements on the motion to dismiss standard, so maybe you can break the tie.
Yeah, just answer in the chat, and I'll send you the I'll send you. Oh, okay, cool. Give me just a second, guys. I will invite Nate, and maybe he can help us out one way or another. All right.
We need a third opinion. That will have 3 lawyers, and then we'll have 4 opinions.
I know. Okay. So yeah. So this whole part where he says that he provided them with the facts after the fact, I don't think that's good enough. But the next paragraph, readers of Insider's first story were misled. Oh, here's Nate. Hey,
can you guys hear me?
I can hear you.
We can hear you.
All right, hold on. I'm hearing you guys on the stream too. So
you're a little quiet to my ear, at least.
Oh, all right.
I can.
StreamYard said the StreamYard bug. Hold on, it might be. Yeah, it's on the wrong audio. Hold on, give me 1 second.
Okay.
We should be better. Oh, nope. It's going to be a little quiet. Yeah, I got to plug in my.
There we go. That's better.
I haven't even done anything, Kurt. You're like, it's better.
Well, maybe it was StreamYard's problem. I don't know. I'm just commenting on what I hear.
StreamYard. We love StreamYard. Okay, this should be better, right?
I mean, it's better than not having StreamYard.
That's true. So I love StreamYard. All right, so my mic is plugged in now. You guys hear me well?
Okay. Yeah.
All right. So what's going on, my beautiful people?
So we're going through this David Portnoy v. Insider defamation complaint.
Oh my God. Another defamation case.
Yeah. Because they published a couple articles about his intimate encounters with women, and it seems like they were suggesting that they were criminally violent and non-consensual. And so he's filed a defamation lawsuit. So I think that so far as to the first article, I think that there may not be defamation, because it doesn't look like they had information ahead of time that he's talking about. That's sort of the smoking gun of like, they should know that this was not correct. But I think that as to the second one, I don't know. It'll be interesting as we go through it. Also, 2012 Jameson says Nate, you need to cover the naked NFL player that tried to tackle the officer. Paid Legalbytes for this, LOL. Yeah, he did 2 super chats now. I got paid 2 super chats so that you could get this information and cover it.
Well, thank you guys. I'm definitely going to check it out. The naked player football. This is you guys are crazy, but I'm going to cover it. I'm going to check it out.
So, yeah. So anyway, so have you been listening in on the stream, Nate?
I want to be fair. I don't want to feel bad by saying this, but no.
No, that's okay. That's okay.
We've all got our my daughter, and I called. I just picked up my daughter. We just literally got home, and I called Kurt. I was going to yell at Kurt for a second. He was like, "Yo, I'm with Alita," and I was like, "Let me see what's going on." And then I jumped in the chat, and
so
I'm here.
So we're kind of in a disagreement about the motion to dismiss standard, because I'm saying so far that there are enough facts here that are alleged that this would survive a motion to dismiss. Whether or not it makes a very strong case of defamation so far, I don't know. But basically analyzing it from a motion to dismiss standard, I think that so far so good. Kurt kind of disagrees. He thinks that there's maybe a little bit too much that's conclusory in nature. So I don't know if you've heard enough to really be able to say whether or not there's enough factually alleged.
Well, the standard for motion to dismiss is simple, right? It's even whatever, assuming everything the plaintiff is saying is true, and right. The defendant can, let's say the defendant concedes everything is true. Mm-hmm. Can the plaintiff still win just based on the factual allegations in the law? And so I'm not sure if they've pled enough, because obviously most of these defamation cases go down to actual malice, right? You haven't pled enough facts to show actual malice,
right?
So now, if the person here, they have to at least plead that there is some facts that determine that they either knew or recklessly disregarded the truth, or knew the truth and disregarded, like in Natasha K, Cardi B lawsuit.
Yep.
Yeah, because they when deposition, she said, "Well, I knew it was true. It said anyway, right? We're past our motion to dismiss." So again, if assuming everything is true, do you think this person would win if the defense conceded all the points?
Mm-hmm. All right. So here's sort of what I was thinking. I think it's Gruskowitz from the Kyle Rittenhouse trial who was suing the city for like $10 million or whatever.
Yeah, Gruskowitz.
All right. Mm-hmm. So Gruskowitz made a complaint, and then in his own testimony on the stand, he revealed some things that were not in his complaint, which to our mind collectively would have massively changed the analysis. And so here's my problem. This initial complaint, to my mind, is leaving out some key things. For example, there is apparently a hospital report that exists. The hospital report is not being described, and they just mentioned it exists. But suppose the defendant brings in the actual hospital report and says, well, look, they didn't have reckless disregard because one of the things we didn't have reckless disregard because one of the things we have that he didn't tell you about is this exact report. And so we're going to lay it out for you and show you this piece of evidence that he didn't tell you about. So to my mind, he's in the same way Gruskowitz was kind of leaving out key details in his complaint. And then we found out things and we're like, this should be dismissed. This is kind of similar. And there is facts that are not here the defendant can bring in that I think would change the picture. And you say, well, the plaintiff is acting in bad faith because they're not telling you the things that you need to know in order to raise the question. So I'm part of in my motion to dismiss is I'm hypothesizing what the defendant will argue in response, which will include the actual police report, which will include the actual hospital report. I am hypothesizing that these things will provide a good faith basis to have their article, despite other evidence to the contrary. Therefore, they can't meet reckless disregard.
But the police
so that's
report,
kind of what I'm thinking.
If the police report is not included in the complaint, it's not part of the analysis for a motion to dismiss. That any kind of facts that the defendant tries to bring in in a motion to dismiss are not used if they're not part of the complaint. The complaint or a motion to dismiss analyzes the facts that are stated in the body of the complaint and the exhibits to the complaint, but nothing else. What you're describing is a motion to not a motion to dismiss, a motion for summary judgment.
Yeah, but here, if that's true, then going back to Graskowitz, we would just look at the initial complaint. We would just look at what he filed. And so
right. The
defendant in that case, the city, would presumably say, well, look, he said all these things on the stand that completely contradict his things. So am I as a judge supposed to ignore all that and just look at the pleadings by its own terms and be like, well, let's assume the pleadings by their own terms are sufficient, which is not clear, but let's assume it. Am I supposed to say as a judge, look, the pleadings on their own terms say there's a case. The fact that you, defendant, are bringing in this extraneous evidence is completely irrelevant to my motion to dismiss. I mean, it's something, I don't know.
Well, I think you both, I think you both are correct, but are missing like each other's points in this sense. You're right. I think Alita's right in the sense of the standard for a motion to dismiss is whatever the plaintiff says is true, and the plaintiff gets all favorable inferences based on what they've presented, right? Because a motion to dismiss is at a stage where generally the defendant sometimes doesn't even have to provide an answer, right? A motion to dismiss will come first. So here's my motion to dismiss. So they generally don't provide any evidence to a counter evidence, right? They'll say, well, whatever the person is saying is not true. But then I also have to agree with Kurt is that sometimes in a motion to dismiss, you can provide an undisputable fact and say, okay, well, the plaintiff says the police report says X. Here is the police report, and this is what it actually says. So I think the judge can then you say, okay, whatever the plaintiff is saying is true, but if we have something that's factually here that obviously is not the case, then they can, I think, use that in that evaluation only in that particular. In that narrow sense, something that they can obviously say is false or true.
I think so. I think the introduction of new facts from the defense in a motion to dismiss usually comes in in an argument about some kind of an immunity, saying that there's because what the argument with a motion to dismiss is it says there is no legal recourse that the plaintiff could get in this case.
Correct.
Under this, because, and so, if they say, because of statute of limitations, for example, they can introduce the date of the injury versus the date of the filing. They can introduce that and say, okay, statute of limitations, we win. Like there are things like that they can introduce certain facts, but it has to it
has to play off
within. What's that?
No, I'm agreeing 100% within what the plaintiff has already presented. But if the plaintiff is only presenting a certain piece of it, and there's another piece that we can add context where you can say obviously, because that's why that whole favorable inferences piece comes in, because the court has to, in some terms, give favorable inferences. But if there's a fact that the inference, the court can come to the wrong inference, because obviously the motion to dismiss is to make sure that we don't waste our time. Why are we wasting our time if this isn't nonsense? So you're right. I think it's very limited, but I think Kurt is correct in the sense of if I can add some context, that's the reason why you file a motion to dismiss, because you can add a memorandum of law and some context to what the plaintiff is saying and saying, well, we're assuming everything the plaintiff is saying is true, but here's the police report. Here's this, assuming all that stuff is true, they still lose. So I think you're right. I think generally it's just all of what the plaintiff is saying, but I do think the defendant can add some context to that in a motion to dismiss.
Okay, that's fair.
But later on, if the judge says, okay, well, there's not enough here in a motion to dismiss it, then you're right. Alito, you'll go through your discovery and then you're going on to your motion for summary judgment, because discovery is, hey, here is the evidence that this is BS.
Mm-hmm. Yeah. So I think so far though, even so,
you might be more right than me. I think on balance, I think you are more right than I am.
Okay. Interesting. Thank you.
So I think maybe I'm going to a motion for summary judgment, and fair enough.
Anytime you feel like you're starting to weigh different pieces of evidence against one another, then you're starting to get into motion for summary judgment territory.
Yeah. Because the defendant at a motion to dismiss early on, there's no evidence that they're providing. They're just saying everything the plaintiff is saying is true and give them all favorable inferences. But if the plaintiff points to a police report and didn't provide the police report, the defendant can, in that motion, here's the police report to add the context to say it's not. So I think that's what Kurt is saying. If you're pointing to a police report, I can give you the police report and saying this is junk. So I think,
I mean, they mentioned the hospital report, they mentioned the police report, so they're acknowledging these things exist, but not giving it to the judge. So as the defendant, I'm like, okay, I'll give it to you. Here's the hospital report.
That's fair.
Here's the police report.
He does reference them.
Yeah, and then if you're saying
they are not what he is purporting them to be.
Yeah, if they are not, if someone says the hospital report says A, and I say here's the hospital report and it says B, that's appropriate for a motion to dismiss, right? Because I'm saying everything is saying is true, and here's the report, and what the person saying in that report can't be taken as true. It's got to be taken as what the actual report says. You're not adding new evidence. You're just contextualizing the evidence.
Yeah. That's fair. Because he does refer to them.
Yeah, because everything else is kind of legal conclusion, right? The underlying facts are the articles. The underlying facts are the social media. The underlying facts are the police report and the hospital report. And so, like, okay, here are all those things. Now here's what I think that means. So but I think you're more right than I am on balance.
Yeah,
I expressed my point poorly. One of the two.
No, I think you both are right. Is that the only thing Alita's saying is, hey, motion to dismiss is extremely limited on what the defense can actually present as evidence to combat it, which is 100% true. They can't actually present evidence. They can only contextualize the plaintiff's evidence. And what you're saying is that there's other evidence that should be dismissed in this case, which is appropriate for a motion for summary judgment. But you can provide that contextual evidence in the motion to dismiss. I hope I explained that well.
Yeah. No, I think that was good. Let me go to a couple super chats. MC says the legal Triforce.
Boom.
2012. Jameson says hospital report might be protected.
Not from the defendant.
Not necessarily.
No. Well, it is technically, but I would assume that they have it or they can get it. So
litigation. So a litigation where a particular document is sensitive, but it is pretty necessary to determine truth or falsity of a certain series of events that are at issue, that can usually come in. So there's always a way to put a protective order on sensitive documents. Any kind of litigation that involves someone's income, tax records are usually going to be requested by the other side. So but usually what you do is you redact all kinds of personally identifiable information like social security numbers, et cetera, et cetera. So there are ways of protecting sensitive information.
I hate to go back to the Cardi B lawsuit, but that's exactly what happened there. Is that they were saying that she had sexually transmitted disease. She went and got her medical records, but her medical records were determined in an in-camera interview, right? Where they went to the judge and said, here's the medical records, you read them. And then the judge had them essentially take judicial notice that, hey, these records don't show that she didn't have this disease. So the records weren't actually put in the record publicly, but the judge saw them in camera interview, and then both sides would say, okay, these records say this. So when it came to the litigation, they didn't have to then review the records. It was already known that these records stand for the proposition she didn't have this contagious disease.
Right, exactly. John O'Brien says that is an motion to dismiss standard. Send me a link. So that's what we were talking about earlier versus MSJ standard. So, but I think we worked our way through that. So, let's continue on in the complaint, shall we? You guys good with that?
I have to bounce for at least a little bit, so I might be back or not. We'll see.
Okay, sure.
Bounce like a rabbit, baby.
Alrighty. Insider's promotional campaign. As if defendants' nefarious intent was not already apparent through their actions prior to and through the publication of the story, just minutes after Insider published the first story, Defendant Black tweeted to her thousands of Twitter followers soliciting more unsubstantiated, quote, tips regarding Mr. Portnoy's private life. Insider made it clear that they intended to double down on their defamatory allegations by planning to publish a follow-up story concerning Mr. Portnoy. To ensure that her tweet reached the widest audience possible, Black pinned her tweet to her Twitter profile, ensuring that her message remained at the top of her feed for all to see. Through February 1st, 2022, Black's tweet remained pinned to the top of her Twitter page. And they have a screenshot of the tweet pinned to the top of her Twitter page.
This is something about legal writing that most people should realize, is that sometimes you can write something and write too much to make a simple point. Because the only thing essentially what they're arguing is publishing, right? This was published to a third party. So the only thing you have to do is just say this was published to a third party and pinned to her, right? You don't have to kind of go through all this, because all of this extra reading is just going to make the judge, who probably is not going to read this, but everybody else mad. Like, why am I reading through all this stuff just to say it was published to a third party? Let's move on. You know what I mean?
Yeah. Yeah. So yeah, and I think, no, I don't know. I don't know what he's really getting at, but yeah, this paragraph probably could be about half as long as it actually is. Seemingly aware that those who live in glass houses should not throw stones. Prior to the publication of the first story, Black took steps to protect herself from online scrutiny. Prior to the first story's publication, Black's public Twitter profile contained 4,151 tweets. Just prior to publication, however, Black deleted nearly all her prior tweets, leaving only 132 tweets visible to the public. I don't know what that has to do with anything.
Yeah, again, this is trying to. You've already got it. This is arguing to an element that you don't have to argue to, right?
Yeah.
Because publicly to a third party, you just got to show that you showed it to one other person. That's it.
Yeah.
That's all you got to do. So
yeah, I think this line of narrative here is going to be about how they used his story for financial gain for Insider, which is going to go to punitive damages.
Maybe the damage, yeah, but again, you don't really have to argue it at this point, because it's kind of irrelevant to the point of we're trying to get through a motion to dismiss so we can get to the trial. Unless
he's looking for a relatively fast settlement, which would include, I would think it would include a retraction, of the story or whatever. So maybe, if you're trying to make it very clear, like, yeah, we're suing for defamation, and yeah, we think we would win, and yeah, we think we would get punitive damages, and here's all the reasons why, just to kind of scare them into a settlement. Maybe, do you think?
Yeah, it's possible. Well, a lot of my work is in pre-litigation. So when I write, like, this wouldn't be what I write in so everybody understands what pre-litigation is that you go to a company and you say, hey, my client's got a case. Here's the complaint that we're going to file. Mm-hmm. They read the complaint. Now that complaint that I give them is different than
called a demand letter.
Yeah. Well, no, I actually give them, it's the demand letter, but I give them a full complaint and everything.
Right. Sorry. What I was referring to is the communication to them before you file is usually referred to as a demand letter.
Yeah. But then I send them a complaint and, all the backup to a complaint. Like everything that I would file in court, I don't file it in court. I send it to them, right? Here it is. This is what I'm going to file. Now that what I send to them is generally has a lot of detail. It's explosive. It's, oh my God, this right, because I'm writing it. I'm writing that document for that audience. This is what I will likely file, right? And that's going to be different than if I actually have to file something, then my audience has changed. My audience is now a judge and probably their court reporter, so whoever they have working in the back. And what I do there is now I write it to be succinct to survive a motion to dismiss. So, I understand, and maybe this was written for public consumption too, because you do have sometimes where lawyers have to write these documents because they know the public is going to be looking at them.
Portnoy did make it very easy for everyone to read this complaint, because he published a copy of this onto his website and sent it out. So I think I think this is also for public consumption for sure. And he says at the beginning of the complaint that this is being filed to clear his name, get his story straight, and to also be compensated for his injuries. So I think that it might very well be that the most important thing to him here is to have his side of the story be told in a way that will be taken seriously.
Yeah, that's fair enough. That's fair enough. So this has accomplished two goals. One, explain why all the stuff is messed up, and two, try to survive a motion to dismiss, which is very difficult.
Yeah. Okay. Simultaneously, Insider unleashed its Twitter army of executives editors, including Defendant Carlson, reporters and employees shamelessly tweeting and retweeting the first story in a transparent attempt to drum up buzz and notably to attract new paid subscription customers. Indeed, the nefarious hit piece served as the launch for Defendant's new promotion on premium subscriptions. On the day of the first story's publication, Insider circulated its 68% off subscription promotion, encouraging the public to sign up using Insider's libelous hit piece as bait. For example, Insider's senior politics reporter, Grace Panetta, tweeted a screenshot of the promotion along with the message, "Heads up, the Insider is currently offering a huge discount on annual premium subscriptions, so you can currently pay just $4 a month to read incredible journalism like Defendant Black's investigation into Dave Portnoy." Okay, so and then there's a screenshot of a tweet that shows that people can buy a subscription to Insider for $49 a year. Concurrently, Insider launched promotion paid advertisements for its subscription service using Mr. Portnoy's photograph in conjunction with a new defamatory headline. Excuse me. Dave Portnoy, Barstool Sports founder, accused of allegations involving sexual violence and humiliation.
Well, so hold on. One thing now is that the Insider seems to have been coaching their language too, accused of this. So it's a little strange to me that these statements are defamatory, like even the statement that you just read.
Mm-hmm.
Is he arguing that them reporting on these alleged statements is defamatory?
Well, so he's alleging that the titles of these articles are defamatory because they're behind a paywall. And so to anyone that doesn't read the article, the titles are enough. And then also that there are statements in the actual article that are defamatory as well.
Yeah, he's got an uphill battle. It's got to be an uphill battle.
Yeah, I think
tough.
it could be. I mean, the titles are pretty spicy.
Spicy headlines though doesn't get you defamation, because it's always going to be about what's in the article.
Yeah.
There have been people that's how the National Enquirer makes all its money, right?
Yeah.
The titles can say almost anything. It's really what's in the article. What are they saying in the article? And it's multiple cases where people have tried to sue on sensational titles, but it doesn't, because the first thing they'll say is, what's the article say? And if the article says allegedly, then he's got nothing. It's unfortunate, but that's generally the way it is.
Yeah. All right, let's keep reading. Concurrently, having been publicly questioned regarding Insider's true motives in publishing the first hit piece as a vehicle to generate new subscribers, Defendant Licea immediately took to Twitter to defend Insider's decision to run a promotion at Portnoy's expense. Broken record here, but the reason big important stories like these are behind a paywall is because people spend months working their asses off and need to make a living. Always subscribe to Insider. And they have a screenshot of her tweet saying exactly that. The next day, on November 5th, 2021, Defendant Carlson tweeted a story from Business Insider concerning Penn National Gaming, which owns a 36% interest in Barstool Sports. In his tweet, Carlson gloated, "Penn National plummets 20% after weak earnings and allegations against Dave Portnoy," because they, I don't know if you know this, Nate, but Penn National Gaming owns it just said that they own a 36% interest in Barstool Sports, which is what Portnoy founded, and I think he's the CEO or something like that. And this was published, the story was published on the day that their quarterly earnings were coming out, apparently.
Yeah, so. Again, I feel bad, but I don't see the I don't see this the defamatory state.
Well, this doesn't have to do with the defamation. I think that what he's trying to get at is there's like some sort of a malicious intent behind it, I think. So, which doesn't go to any of the elements of defamation as we went through them earlier, but I think this part of it is maybe more the PR piece aspect of the complaint.
Yeah, I agree.
Okay, let's continue. Perhaps most indicative of defendant's malicious intent, in the days following the first story's publication, insider employees began contacting Barstool Sports advertisers, informing the advertisers of the false allegations against Portnoy and inquiring whether those advertisers would continue to advertise with Barstool Sports. For example, on or around November 6, 2021, insider correspondent Patrick Coffey emailed a Barstool Sports advertiser stating, quote, "I would like to ask whether leadership was aware of this recent story about Barstool Sports founder, and if so, whether there have been any discussions regarding those partnerships and or ad placements," unquote. Defendant's conduct was intended to shame Barstool Sports advertisers for working with Mr. Portnoy and his company and encourage them to stop doing business with Mr. Portnoy. This so this doesn't have anything to do with defamation, but I wonder why they didn't add a claim in here for I don't know,
tortious interference.
Yeah. Tortious interference with somebody else's business relationships. This is a business agreements that they have with him. We talked about this about the Joe Rogan situation with Neil Young. The reason that he probably took down his open letter to Spotify saying it's him or me was probably because some lawyer pulled him aside and said, "Hey, by the way, you can maybe get sued for that because you're interfering in somebody else's contract. You're trying to tell Spotify what to do with a contract that they have with somebody else."
But the issue is that so everybody, what is tortious interference? Because I know people are probably like, especially on the podcast, I'm like, what's tortious? Tortious interference is if you do something that is civilly incorrect to a company that forces someone else to change a contract, leave a contract, or do something like that. So, for instance, if I say Joe Rogan is a racist, and that's incorrect, right? That's defamatory. I've defamed Joe Rogan. And companies now say, well, listen, let's say Spotify says, well, since I've said Joe Rogan's a racist, and if I'm wrong, right, if I don't have any evidence to back it up, if I've defamed Joe Rogan, and Spotify then cancels his contract, that's tortious interference, the tort of defamation. And because I've wrongfully committed that tort against Joe Rogan, this company left. So that's tortious interference. Because I created this tort, I interfered with his business contractual relationships. So here, I think they're trying to make that same argument that because of the defamation, they allegedly were committing this tortious interference. But the reason why I think they may not have made that claim is because for tortious interference, you also have to show that defamatory conduct did actually interfere with a contract. So here, I don't think they have that. They don't have that. They have the defamation, but they don't have the tortious interference with the contractual agreement.
That's fair. There may not have been any actual harm in that, but if any of the advertisers did in fact pull away from Barstool Sports because of that, there may have been a claim for it. That's fair. That's a good point.
But then you would need them to come in or something from them to say the reason why we haven't done this was because of this tort or this defamation.
I mean, if it's been a longstanding agreement, and there were previous communications between the two contracting parties that saying like, yeah, we're happy to continue this for a long time, and then all of a sudden they're like, actually, and that lines up. The timing lines up perfectly with the publication and these messages that people are sending out to them. Like you can infer circumstantially, from those pieces of evidence. You don't necessarily need to have the other advertisers say, yeah, this is the reason why.
Yeah, correct. Yeah, you're right. You could build a circumstantial case based on an inference. Yeah, you're right.
Yeah. So, interesting. So my guess is that but I think that the reason for this is the reason why they're adding this element into the narrative is probably for two reasons. Number one, for the PR piece, because Insider looks dirty, because not only are they publishing this article, but they're trying to make Barstool Sports go away financially by hitting their advertisers, which that doesn't seem to have anything to do with Insider, doing what a publishing like a news publishing company should be doing, right? Like they should be writing articles. They should be investigating investigating things. But like then going to Barstool Sports advertisers and being like, "Hey, are you sure that you want to be that you want to be working with this guy?" Like that looks a little dirty. I'm not going to lie. But also the other thing is well, if these advertisers didn't actually, pull away from Barstool Sports, then I guess there's no harm. But I was going to say that the other reason why they might be showing this is to show the financial harm as a result of the defamation. But that then I would really be wondering why they didn't add a claim for tortious interference with a business relationship.
Yeah, agreed.
Yeah. Last paragraph in the section. To a large degree, defendants succeeded. Due to defendants' deliberate interference with Barstool Sports business relationships, Barstool Sports has lost no less than $12 million in advertiser revenue since the publication of the defamatory first story. Okay, so then why didn't they add that? Why didn't they add a claim for tortious interference?
Because I don't think they have the facts to back that up. I think that's they're probably just saying this is how much money we could have made or something like that. No, and they don't have enough evidence to say because of these particular statements we've lost this money. So in other words, it's easy to say, but then I don't think they knew. I'm assuming they felt that couldn't survive a motion to dismiss. So let's just say it, but not claim it. It's actually a nice tactic to get the judge thinking about something else while you're arguing defamation.
Interesting. I still think that they probably have all the elements to allege it, but maybe they want it to be, because I mean, yeah, I don't know.
Well, you could amend the complaint too, right? You can also
yeah, that's true. They maybe the lawyers just missed that one. Like that's always possible too, right? When you put together a pleading and you're like, all right, this is exactly the way that we want it, and then you're like, oh shit, we totally forgot a whole section.
But missing tortious interference. All right, business, contract, defamation. Tortious interference is just like something that comes naturally from those three things, right? I don't think there's any lawyer who works in the field. Well, I'll say this: the lawyers that I work with, and I've worked defamation cases before. The first thing you think about, you got business, contract, defamation. Tortious interference is the natural end result of all that, right? True. I don't think it's like not saying. I don't know. Unless it's just bad lawyer, but yeah,
it's always possible.
It's a gimme.
It's possible, right? I mean, hey, sometimes mistakes happen. So, okay. Insider publishes a second false and defamatory hit piece. Now, this is where I think that there might be a suggestion, there might be a stronger case for defamation, I should say, than the first one, because before the first piece, Insider did reach out to him and asked for him to talk about his story or whatever. They did not suggest that there was anything of this nature in it, but they did offer to talk to him, and he said no thank you. And so the information that he says that they had in not retracting the story was like text messages between him and these women. He gave those to them after they already published the article. So as to the first article, I don't know that there's enough there for defamation, but he doesn't need to have both articles be defamatory. He can win with one article being defamatory. So let's see how this works out here. Also, I see in the chat. What's up?
Well, two things. Number one, so Insider has women who are telling them this, right? So that's number one. So they do have a source. Their sources have provided them some information, right? He provides counter information, which are these text messages, and they are saying we're gonna. So he's saying because he provided these text messages, they absolutely prove that he's innocent, or absolutely prove that these are false. So really, it seems like all this is based on the strength of these text messages. What did these text messages say?
So the text messages, we haven't seen them, the ones from after the events, but there was a Finsta account, a fake Insta, which is, a private, it's defined as a secondary Instagram account where the user's identity and often the content of the user's post is unknown to all but a small, carefully chosen group of followers. So basically, one of the women had a Finsta account where she posted more directly stuff about being with Dave Portnoy on the weekend that she was there, including me beating Dave Portnoy in Scrabble. And then the next day, she says, it says in we're on page 14 of the complaint, where she says, on July 20th, 2020, after having consensual sex with Mr. Portnoy, Madison then posted a video to her Finsta account revealing her true motivations with Mr. Portnoy. In the caption to the video, Madison wrote, Portnoy was a D and lame and grumpy. And I redacted D, guys, for anyone listening. He gets a 2 out of 10 from me. If he ever truly pisses me off, I have lots of content to expose him with. I am going to stick to athletes, with dollar bill with wings emojis, a bunch of them following it. So, and then later she posted a picture of Mr. Portnoy with Donald Trump, and the caption to the photograph, Madison wrote, okay, not my proudest F. So there's that kind of stuff that Portnoy says that they had access to and they should have seen. So I don't know if that means that they actually did have access to them or they actually did see them. But I think that it sounds like what he's saying is that he gave the text messages, and I believe he gave the access to the Finsta account to them. And I think that those statements from the Finsta account seem like, okay, like they do suggest a different narrative. What do you think, Nate?
Yeah, I agree. I think they do suggest a different narrative. But the thing with actual malice is that I don't have to prove that, unless he can prove that based on what we're seeing, these statements were absolutely false. Like, again, and I hate to go back to the Cardi B, but in the Cardi B case, right, they were able to show that the statements were absolutely false, and the person knew, a reasonable person, and that person knew they were absolutely false, right? Because the person literally said, I never met Cardi before. So that was the proof that they had to show that that her statements were absolutely false. So unless they have something like that, now, if he's admitting that they had some type of relationship, that that he did bang this chick, then I think it's going to be harder to prove, because you don't have, because it's such a low standard to just show like, hey, I had some reason to believe this is true. You had sex with this woman and this is what she's saying. It's just going to be hard to overcome that. Versus, I never met this woman. I never met this woman. This woman's totally lying. That's different than I met this woman. We had a sexual relationship, and what she thought of the relationship is not what actually was the case. That doesn't win a defamation case. That loses one.
Okay. And one more point before we go on. Somebody in the chat mentioned that Emily D. Baker said that a claim for interference with contractual relationships, or tortious interference with contractual relationships. Kurt, when you were gone, welcome back, by the way. When you were gone, we were talking about why that wasn't added as a claim here. I guess Emily said yesterday in her live stream that it's because he's suing in his personal capacity, and Barstool isn't a party to the suit. So that makes sense.
Did Emily have a overall opinion on the strength of this case in motion dismissed land? Just out of curiosity.
I didn't remember, or I didn't see her live stream on it. So I don't know, but maybe somebody in the chat did and can tell us. So anyone in the chat, if you watched it, let us know what she thought. Okay. So Insider publishes a second false and defamatory hit piece. we're going to move on. To make matters worse, on January 18th, 2022, defendants Black and Licea again emailed Mr. Portnoy informing him that Insider was planning to run an additional defamatory story. In that email, Black and Licea requested that Mr. Portnoy provide a comment for their second story. Insider's comment request email contained an additional 28 bullet points of false and entirely unsubstantiated allegations. In their email, Black and Licea informed Mr. Portnoy that Insider was ready to publish the second story, and they demanded that he respond within 48 hours to the new maelstrom of false allegations contained therein. In response to the comment request email, on January 19th, 2022, counsel for Mr. Portnoy transmitted a legal letter to Insider, putting Insider on notice of the provably false allegations contained in the proposed second story, providing Insider with documentary evidence directly contradicting the malicious allegations contained therein, and demanding that Insider refrain from publishing the second story. Defendants published the second story anyway. So I think that, you know, what's been alleged in this last paragraph, I think is enough for alleging actual malice. But like whether or not that ends up being a good case or not depends on the kind of content in that information that was sent. What do you guys think?
This is where, all right, so they reach out, they say, we're going to publish this story. He reaches out and says, hey, this is false. Here's the reason why. So this is kind of like Dominion and Rudy Giuliani, right? They send the letters with all the evidence saying that this is false. This is the reason why. And then they still say it anyway. So yeah, I think you're there, but it then all depends on what the hell they sent over.
Yeah.
Because the judge,
as far as how strong his claim for defamation is. Yes.
Because now, and I think this is what Kurt was mentioning before with the motion to dismiss standard. They've raised this as a triable issue and saying, okay, as a motion to dismiss, this is what our evidence is, right? Mm-hmm. So now if the other side was to say, well, okay, here is what he wrote us, and this is the reason why you don't have actual malice, then I think they can still lose. So it really depends on what did they present. If they presented and said, hey, everything she's saying is false, that's not enough to overcome actual malice, right? You have to they got to show something that's pretty compelling. They got to show something that's, just to be honest, they got to show something compelling. You know, that the reason why these are fake. I don't know what they showed though.
Right. Because it's whether or not they have actual malice depends on the content of what kind of objective evidence he sent them. That's more than just him saying it didn't happen that way.
Yeah, and as before, I still think when is the critical question.
So we're now in between Article 1 and Article 2, where they reached out to him and said, this is what we're going to publish. Mm-hmm. Do you want to comment on it? And so he responded with his lawyer. So the timing of it is before the second article.
That would work.
Yeah. So we don't have that issue that the first article had, where he sends a bunch of text messages afterwards and says, see, all of that is false. All the stuff you said in the article is false. So that, he doesn't have a timing issue in this one.
Okay. Excellent.
Yeah. On February 2nd, and I made this point earlier when you were away, Kurt, that, you know, the first article can technically not be defamatory and the second one can be defamatory, and he wins. Like, he doesn't need both articles to be defamatory in order for him to win. There only needs to be one false statement that they published with actual malice.
Sure.
So, okay. On February 2nd, 2022, defendants published their second defamatory hit piece on businessinsider.com titled 3 More Women Say Barstool Sports founder Dave Portnoy filmed them without asking during sex. So this is an allegation of fact, and it definitely suggests criminal intent, that title. Do you guys think that title is enough on its own to be defamation for people that don't have the paywall?
I mean, yeah, it would be in Massachusetts because of the 2-party consent rule. Okay, I'm on board.
Okay, yeah. All right. Oh, and there's a hyperlink to the, and it goes to it. And is there a paywall? Yes, there is. That's fun. Okay. StreamYard is going to be stupid about me changing tabs around right now, so I'm not gonna show it. So, but take my word for it, guys. It's still behind a paywall.
Yeah, but headlines. that lead to videos, it's difficult. It's difficult. Yeah, it's difficult to I don't know, the claim.
Yeah, I think it's definitely not the strongest argument, right? It's not the strongest argument, but I think that it's an interesting argument to make. I've never seen someone make that kind of an argument before about a title specifically, but I think that's also because usually, I mean, before the days of internet articles, you know, like when there were, you know, now paywalls, like now you can see, like it wasn't always the case. Like when we didn't have the internet and people got all of their news from newspapers, you know, like typically you would buy the newspaper and then you would see the title of an article, right? Like that was different than now, where you can see the title of an article, you can see even the first couple lines of it, and then something will conveniently pop up and say, sorry, you can't see this because you need to pay for it.
It's like that extra, read all about it. You know, man bites dog. All that is not defamatory. The defamation is reading the article, and those articles are making factual statements that could be proven false. Now, even in this article, you know, 3 women say blah, 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 blah. Those are all facts, right? These 3 women are saying this.
That's true.
But that doesn't mean it's actually true. And then you can read the article, and the article can say, hey, these statements seem false, right? It can add the context to it. So, yes, it's going to be tough to win a defamation just based. You're saying you don't like the title of the article.
The problem there is republication, because you're saying they said. So now you are republishing those allegations. So now you're on the hook for it. So yeah, it's literally true, but you're republishing the allegation. So you're on the hook for that.
Yeah, but as long as I tell you their allegations, right? I'm allowed to republish allegations as long as you know their allegations, right?
I guess no. Still, it goes back to the primary issue, because you're republishing the actual allegation, which means that it goes to your overall knowledge about the evidence that you have to its truth or lack thereof. And here it seems a little bit more firm for David than it did in the first count. So yeah, I'm good. At least based on what I understand at this point.
So let me finish this paragraph. For search engine optimization and clickbait purposes, the second story's URL included the words and phrases Portnoy, new woman, sexual misconduct, filming, sex, and without permission. Further, the second story, like the first story, was published behind a paywall, requiring readers to sign up for Insider's paid subscription service to access it. So we talked about this earlier about the URL. I think more people in the chat read the URL than people that don't. I personally usually don't pay attention to the URL, so to me that was kind of surprising. I mean, beyond like if this is actually businessinsider.com, you know, like I should have clarified that. You know, like I don't just click on a random link that I see. You know, because like phishing scams and all that kind of stuff happen. But like, you know, with like all of these different like words and phrases that come up after the slash, I don't necessarily pay attention to that. So that to me is interesting that some people really do pay attention to that. So, you know, the fact that they have these different phrases that are coming up, like new woman, sexual misconduct, filming, sex, and without permission, it's interesting to me. And I wonder if that adds to the argument about the title itself. Nate, what do you think? Does that change anything?
The search engine stuff, not really, because those aren't statements of fact. They're just trying to get the search engine out. But even though it's just I don't know. It's if you can report someone saying someone else did something bad, because I do understand the repeater rule. But if there are definitely those 2 exceptions. I make it very clear that these are allegations, they're not truth, and that someone else is alleging them. And you know, unless you know that what the person is saying is out and outright false. And again, I hate to point to the Cardi B stuff, but Cardi B didn't even know the woman, right? The woman said, I never even met Cardi B, and then started making those allegations that she knew her. So that's how they absolutely knew those were false. Here, unless you have something, again, I think it really depends on what the insider has to prove that they should have known this was false.
Yeah, I think that there are two ways of writing this title. One would be defamatory, one would not be defamatory. I think that maybe to Nate's point, you could change this article title to be defamatory if it says Barstool Sports founder Dave Portnoy filmed 3 more women without asking during sex. If they said that, that's more of a statement of fact rather than saying 3 more women say, because they're just reporting on what somebody else says without asserting the truth or falsity of that statement.
Yeah, agree.
What do you think, Kurt?
I posted in the private chat a link to a good article from the Volokh conspiracy, which discussed a lot of these issues a couple of years back on whether or not republication of rumors and by saying they allege certain things is defamatory or not. They go through a lot of extensive analysis. It's complicated, but the generalized principle is that even if you say it was someone's allegation, then it still is libelous. Then of course you still have to get into a whole bunch of other analysis on top of that, but you can't be saved merely by saying that they said that they alleged it, and that's literally true. The republication rule is a rule that's going to be a problem.
Okay. So yeah, I'm looking at. Do you want me to share it?
If you like. I mean, it's a good article. I mean, it's a little. Yeah, I just thought it'd be interesting.
Yeah, I think we don't need to go through the whole article, but that's okay. Yeah, let me share this. All right. Okay. Is accurately repeating a defamatory allegation itself defamatory. Say that Don writes, Teresa alleges Paul committed armed robbery. Don's statement is literally true. Teresa did allege that, but the statement Don is reporting on, Teresa's statement, is false. Can Paul sue Don for defamation and win? The republication rule says often yes. American defamation law has long adopted the republication rule under which Don is potentially liable for defamation if Teresa's allegation actually proves to be false, even if he expressly attributes the statement to Teresa. You can tell that Don was destined to be a defendant just from the first letter of his name. Ha! D for defendant. Okay. The principle is that tale bearers are as bad as the tale makers. And this is true even if Don distances himself from the allegation, for instance, by saying that Paul has denied the statement or that Teresa has reason to lie, which held that C. Martin v. Wilson Publication Company, which held that reporting a rumor that a local developer had been guilty of arson could be defamatory, even though the newspaper expressly said that, quote, some residents stretch available facts when they imagine Mr. Martin is connected with the fires, and that, quote, local fire officials feel that certain local kids did it for kicks, unquote.
Yeah, so the republication rule, even if you're saying these 3 women are alleging this, in many states and in many contexts, that itself can be defamation because of the republication rule. So that's why I was pushing back on that.
That's a very, I mean, this is directly on point to what we were saying.
Yeah.
Yeah, no, I definitely agreed with the republication rule, but the instances is that all news media, there's, well, and again, this may go back to the intent element, the actual malice, or even the negligence element to this. But generally, repeating the statement verbatim or repeating the statement as a factual claim, that will definitely get you in trouble. But freedom of the press and then the intent element, that's why the actual malice comes up. Okay, well, did you know that these statements were false? And right now, if we're claiming that it just doesn't seem like, even in republishing them, the thing that saves these news media organizations is the actual malice piece. So
I'm 100% with you on that. I'm 100% with you that you still need to show the actual malice, and the fact that they're telling you that is information that you can rely on if they seem reliable. So yeah, I mean, I totally agree with you. You still need the actual malice element.
Yeah. So what I'm saying is that even though this is on point for the element of republication, right? We're talking about the third element, the publishing to a third party. Yes. So this is on point for that. But I think the attack to this claim would be based on the malice piece of it, not the actual whether the repeater rule, that's what they do call it, the repeater rule is in effect. Yes. But I don't think the repeater rule is the repeater rule is the point in which this case fails. I think it's still going to fail based on actual amounts, because even though you repeat it, which all news media repeats it, they save themselves by saying this is an allegation by these people, and that's how we don't know whether it's true or false. That's why we're saying it's an allegation.
Yeah, well, with public figures in particular, when you have the actual malice,
yeah, interesting. Okay, so according to this article and the case law in it, the Velo conspiracy article in reason.com, it seems like, which I'm going to link to that in the description below as well, in case anybody is interested in looking further at that. So it seems like this kind of a statement could be potentially defamatory, but again, we still have all the other elements of defamation.
I gotta go pick up another baby, so I will see you guys. How long you guys going to be at this? How long you guys been at it for 2.5 hours now, right?
I know.
We're past the 2 hour mark, so at this point we can say any words we want.
Oh yeah, that's the Nick.
Yeah. Oh, let's see. So yeah, I mean we're gonna get to the end of the complaint. I'm not going to read through the actual articles themselves that are attached to the exhibits, but I'll link to it so that anybody can read it for themselves if they want to. But yeah, we've made some good work through this. All right, it was good seeing you, Nate.
Yeah, good seeing you guys too. Good luck with this. Is a banger.
Thanks. See ya. Okay, so now as to Kayla in the second article. The thrust of the second story pertains to a fabricated account of Mr. Portnoy's alleged encounter with a woman referred to as Kayla. In short, the second story falsely accuses Mr. Portnoy of sexual assault and forcible rape. Defendant's narrative of events is preposterous and critically belied by the evidence in defendant's possession. The second story alleges that Kayla first messaged Mr. Portnoy on Instagram in the summer of 2017, and that Kayla eventually took an Uber to Mr. Portnoy's house to visit him. Defendants further allege that Kayla and Mr. Portnoy had violent sex and that it was just way too much. Kayla further alleges that Mr. Portnoy filmed her without permission. However, despite Mr. Portnoy's alleged violent and non-consensual conduct, Kayla was eager to see Mr. Portnoy again.
I don't like that because it's not clear when Kayla learned that it was filmed without permission. If she didn't know that when she went to go revisit him,
yeah,
right.
If she knew that she was being filmed while this was going on, and she continued and she didn't say anything, then there's implicit consent.
But when did she?
According to Massachusetts law,
information is not clear.
Yeah. Yeah. About 1 month later, Kayla again visited Mr. Portnoy at his home in New York. Defendants went on to report that the sex during her second encounter was far rougher than she had anticipated or would have agreed to had she been asked.
I'm confused. She said that the first encounter was violent, correct?
Yes.
So she knows that he likes that kind of... I'm confused.
Yeah. She knows that he wants it like that. And she's going back to him for that. I wonder if she had made any kind of statements leading up to it. She would have definitely had plenty of opportunity if there was a month in between, to say, hey, I wasn't okay with that, or hey, can we go in this other direction instead? Kayla further admitted,
so assuming those things exist, and Kayla comes back in her response and says, wait a second, during that prior month, here's some text messages that shows that I wasn't happy with it and said I didn't want it as rough, and he was saying okay and all the rest of it. It's like, can I as a judge consider that in the motion to dismiss? Because Kayla
further admitted that yes, it was technically consensual sex, but that was not the sex I consented to.
That's confusing.
That is confusing. That is a very confusing statement because it is suggesting a lack of consent, but at the same time,
suggesting consent.
Yeah.
Like you can, I mean, at the risk of stating the obvious, you can obviously consent to sex and it can be consensual at the start of it, but consent can be withdrawn and it can become non-consensual.
Yes.
So, and that non-consent could be based on the nature of the behavior of the person. It's like, oh, I don't like that. I don't like that. Stop doing that.
Right.
And like, so I didn't consent to that much. So yeah, I don't understand this. She's saying it was technically consensual the whole way around, but I don't understand.
Yeah. I mean, it's taking that quote. I mean, that quote may have been cherry picked out of the article too. There may have been some context around it that makes her lack of consent clearer or her consent clearer. So yeah. So there is that. This, like I said, it may have been cherry picked. That maybe this was a situation where she did revoke her consent because of what was going on. Or maybe she had the opportunity to do so and didn't, and then later regretted it. Either one is a possibility here.
Yep.
Okay. Defendants also falsely reported that Mr. Portnoy attempted to force Kayla to have, a special kind of sex. Anal. Okay, I'll just say anal sex during this encounter, and that we're past the 2-hour mark. And that Kayla had injured her rib from rough sex. At a minimum, the second story implies that Kayla's encounter with Mr. Portnoy was not consensual and was so impermissibly violent as to constitute sexual assault.
Does it though? Does it?
I don't know.
Does it imply that it was non-consensual?
I don't know. I mean, that will be more clear if we read the article itself, which, as I said, is attached as an exhibit. So we won't have time for it today during this live stream. But if you guys want, go ahead and read it. The allegations concerning Kayla are provably false. In reality, Mr. Portnoy and Kayla engaged in consensual sex, and defendants were fully aware of that fact. How were they aware? Oh, because of the communications between his lawyer and their lawyer, perhaps. I wish they would have said that, though. I wish that would have been that would have been a continuation.
It doesn't mean anything to me.
Yeah, I mean, you can maybe piece things together. I mean, it's a court can piece pieces together though, because you take the complaint as a whole.
True.
So it's not that it leaves me wanting, before this period here, I want a because.
Yep.
Okay. Indeed, in messages that post-date the alleged violent sexual encounters between Kayla and Mr. Portnoy, Kayla repeatedly referred to those past interactions in only positive terms. In March 2019, after describing a really good, albeit scary, aggressive sexual encounter she supposedly had with another male celebrity who, according to Kayla, would, quote, pin her down, choke her a little, slap her around a little, and bite her, unquote, Kayla teased Mr. Portnoy about his sexual prowess and suggested they get together again. Okay.
Well, this goes to show falsity, but
yeah,
how they know about that is another problem.
That's another problem. Yes, exactly. Would they have seen these text messages beforehand? Okay. Several months later, in an unsolicited message, Kayla informed Mr. Portnoy that he would 100% get laid if he helped her find a home for a certain rescue animal.
I don't know why this strikes me as funny, but it does.
Yeah, I don't know. And while the second story claims that it took Kayla months to process what happened to her, 2 years after the alleged non-consensual sexual encounter, Kayla again messaged Mr. Portnoy, quote, miss that D. Okay, and there's some screenshots between them. You'd appreciate this with smirky emojis. Effing hot. Figured you'd like it. Miss that D. That's what they say. At no time during her extensive text message exchange with Mr. Portnoy did Kayla ever complain about him being violent, abusive, or recording her without her permission. Allegations that Mr. Portnoy unequivocally denies. In fact, Kayla joked about how she injured her rib during one of their sexual encounters and boasted to Mr. Portnoy that he, quote, still holds her title for
Is he
most
suing
aggressive
her
sex.
as well as the
No,
paper?
He's not.
I wonder why.
He doesn't need to. I think I'm wondering if maybe he I don't know. I mean, he could sue her as a doe defendant, right?
Sure.
You know,
well,
that
would, but I'm not very happy with the whole John. If you actually know who they are, I'm not happy with John Doe's, and I'm not happy with redacted names and pleadings. It's a personal pet peeve.
Yeah, I mean, it's just I'm wondering if it's just because of their personal names and whatnot, like not essentially doxing them by lawsuit, but it's I don't know. That isn't the best reason in the world if you have a legitimate claim against them.
Yeah, I'd mention them by name. I wouldn't think twice about it. You know, especially if they're the one defaming me, the fact that I'm exposing them, just like they attempted to falsely expose me.
Maybe
like
he
they
doesn't
were mentioning
want
me by name, so I don't know what the problem is.
Maybe he doesn't want the public backlash of like, you know, where the narrative has been he's this, you know, famous, powerful, wealthy person who's like, you know, going after these girls, and then to have that blow up in his face further because he's, you know, supposedly gone after these girls, and then he also sues them on top of everything. You know what I mean? Like the potential counter narrative might be too much for what he wants.
I also like that, as a interesting note, and not that you necessarily expect anything different, but I just think it's interesting that if we were both judges and we're both trying to reach for, you know, the height of what law is, you nevertheless we get a different experience from us. And I just think that's interesting.
Mm-hmm, mm-hmm.
Maybe you think it's less interesting. Maybe you just think that I'm wrong.
No, I think it is interesting. Let's continue on. Again, Mr. Portnoy's counsel provided defendants with the true facts and documentation concerning Kayla, but Insider ignored the information because of their preconceived agenda. In particular, Insider was made aware that critical text messages were available to them, but Insider again did not even request copies of them from Mr. Portnoy or his attorneys. That's not as strong as they had copies of the text messages.
Yep.
That's not as strong. I think that, you know, there probably still is enough, you know, to get this complaint through. But as to the strength of the actual allegations themselves, I don't know. I'm not particularly optimistic so far about the strength of this lawsuit against Insider. Where Insider did include information from Mr. Portnoy, Insider made an affirmative effort in its presentation to minimize its import. That's, I think, within the actual malice standard, though. You can say, hey, we saw it, we saw information, and we don't think it's credible. You know, like these are self-serving statements from him, for example. And therefore, you know, we believe the woman as opposed to Dave Portnoy. Continuing on, despite the fact that prior to the second story's publication, defendants were provided with Kayla's post-dated communications with Mr. Portnoy and were fully aware of the problems with her sensationalistic accounts of events and the fact that defendants' in-house counsel promised to, quote, be in touch to give Mr. Portnoy ample time to comment, defendants published the defamatory second story anyway.
Did they get in touch? Did they give him the opportunity?
I guess not. That's the implication here, because they had an exchange. They had an exchange of communication between his lawyer and them, right? But I don't know if this promise to be in touch is in addition to that. You know what I mean? Like this is where, like, you pointed this out earlier, but it's starting to get a little bit annoying. The when certain things happened are getting a little bit fuzzy between these various communications, because it's like the way to do this to make it super crisp is to say, on this date this happened, on this date this happened, on this date this happened. This is false because they knew of this, because, you know, like using a lot of becauses, using a lot of dates, that usually really helps to bolster the factual claims in a complaint. So, anyhow, Insider runs its second promotional campaign. Okay. I mean, the promotional campaigns, to me, they don't do anything for these claims, but we'll read through them. Insider again ran a promotional campaign for their subscription service in connection with the release of the second story behind a paywall. Again, Insider's Twitter army of executives, editors, and reporters advertised and promoted the article, seeking further subscription revenue. Defendant Black again tweeted to her thousands of followers, seeking further dirt into Portnoy's private life. Quote, if you would like to share any information connected to this story, you can reach us securely at juliablackjourno@protonmail.com and Melkorka Licea at protonmail.com, unquote.
No, if I'm the defendant, I'm going 100% the other way on that one. It's like, yes, of course we did that. We were, of course we did that. We were trying to find out all the facts that were relevant so our article could be as well informed as possible. You're accusing us of reckless disregard as we're actively going out into the world seeking more information.
Yeah.
I mean, come on, right?
That's fair. Yeah, that's a very good point. Anticipating the backlash from the outlandish allegations contained in the second story, Defendant Carlson published an editor's note on Insider's website titled "Why Insider Published Its Dave Portnoy Articles." In that article, Carlson further defamed Mr. Portnoy. Excuse me. Oh, sorry. In that article, Carlson further defamed Mr. Portnoy, stating that he took a sexual encounter that began consensually and turned it violent without first asking his sexual partner for permission. Carlson,
I mean, that might be literally true, and I guess goes into a more generalized idea of when do you need to ask your partner for specific permission to do things is a reasonable question.
Yeah.
I don't know the answer to that. I don't think there's necessarily, I don't know. I don't think there's necessarily a legal obligation. Do you think there's a legal obligation to ask before attempting to do particular things once you have generalized consent for the overall activity?
It's such a difficult question. It depends on context. I feel like, you know, I hate to give the lawyer response, but it depends, right? It depends. I think that where a change in events is happening and the other partner is responding in a way that seems to suggest that they are continuing down that path with you, that would imply consent. And if they don't say otherwise, they don't do anything that indicates otherwise, that implies consent.
Okay,
so
fair enough.
Yeah.
A measured answer.
Thank you. Carlson further described Portnoy as a rich, famous, and powerful person who uses his power in a way that is harmful to other people.
I don't like that argument at all. I mean, that's an opinion. So that's fine. You can have that opinion. I just don't like the argument because, again, I'm back to can a woman consent or not to having sexual relations with a rich or famous and or powerful person? Can a woman consent to that? Is that an okay thing for her to do? Is it okay for her to make that decision? Or is it not okay for her to make that decision? And if she can make that decision, it necessarily means the other person's involved. So what are we talking about? I get very confused on this point.
Yeah.
Do you disagree with me?
No. I do agree with you, because I mean, you're right. If it were the case that his power and his wealth and his fame were to be used against him, in other words, to be used as evidence that she is not consenting, then that would mean that no one in an unequal power dynamic would be able to ever consent, ever.
Right.
So that means that no woman can ever be with someone like Dave Portnoy unless she's within a particular financial
band of
class or whatever,
particular band of equal power. Yeah, that would be the implication, right? Yeah, exactly. It's like, can that truly be right? I mean, that seems odd.
I don't think that anyone would agree that that's what, like like we talked about Aziz Ansari earlier, the friends of mine that were, talking about the power difference and that kind of thing. I don't think that any of them would start to argue. I mean, I don't know, maybe I should ask them, but I don't think that any of them would.
Yeah. Ask them the question.
Argue.
Yeah. Ask them the question I would ask you. Is it okay for her to consent? In principle, is it okay for her to consent to having sex with a rich, famous, and or powerful person? Is that an okay decision for her to make? Should she have the autonomy and the right to make that decision for herself? If the answer is yes, then what are we talking about? How can it possibly be okay for her and not okay for him when her decision necessarily implicates him?
Yeah.
That doesn't make any sense.
No, that's very logical.
That's what I do. That's how I roll.
Britt Cormier says, even of equal class, would it be the same? If he has a public platform with 1 million followers, someone would say she is less powerful. I mean, yeah, because then you can start getting into definitions of different types of power, different types of wealth. What if one has power, one has wealth, and one has fame? One has beauty, one has, not so much beauty. You know what I mean? Like that's there are so many different ways that we, like, from a sociological standpoint, that we ascribe power to a person, and when you try to stack them up against one another, you can't really do that in an evaluative way, right? Does that make sense?
Yeah.
Or am I speaking a little bit too metaphorically or whatever?
Yeah, and anyway. I don't think the answer can turn on perceptions of the experience that don't raise legal issues. So if a woman makes a decision to have sex with a rich, famous, and or powerful person, if she tells her girlfriends after the fact, geez, it was wonderful, it was great, I was swept off my feet, I had a wonderful time, all of her friends presumably are going to say, you go, girl. I don't think one of her friends is going to say, wait a second, you were violated because he had more power. I just, if she's happy with the experience, I don't see them saying that. So,
and I think part of that too,
it can't turn on her subjective experience of how good or not it was. That can't be the right answer.
And I think also there's, I don't know if maybe I'll get in trouble for saying this, but I think that for some women, there's also an element of her taking power by being with a man that's outside of her class.
Yeah, that too.
Like there's
yeah, I think that's true. And Ben Shapiro has also raised this point about the casting couch. Like, is the casting couch acceptable in principle? Because should a woman be allowed to make the decision to, sleep with a powerful man in order to obtain, a part in the movie or other benefits? Because, hopefully the only thing you're obtaining is not sex. Hopefully you're obtaining other things along with it. So it's like, is it okay for her to have that motivation of that, and that be a basis for her to make that decision or not? So is the casting couch in principle acceptable or not? It's like, should she be able to make that decision for herself? If so, then it can't be wrong for the guy. So it's like, what are we talking about? What is the, what's the rules here?
I think some of it has to do with the context of the offer. If it is stated as a true offer that is freely given and freely accepted or freely rejected without any consequence, I think that's different than Harvey Weinstein.
Yeah, I think that's fair enough. I think if you don't sleep with me, I will hurt your career. Yeah. That's extortion. I mean, that's extortion. If you don't sleep with me, I will do something negative against you. That's just plain extortion. That's criminal.
Yeah.
If you sleep with me, I will benefit your career. I mean, that's not extortive as long as I don't do anything if you don't make that decision with me. God, it's like, I don't think that's extortive. And that, of course, doesn't have to be explicit. It's implicit. But yeah, I agree with you. If they don't sleep with you and you hurt their career, you're just extorting them and you're committing crimes.
Yeah. I think but let's put this in like a normal employment context. Let's say there's a woman and it's her boss.
Right.
Making that offer to her. She's faced with a dilemma of either, let's say, I mean, if she's game, okay, fine, whatever. But if she's not, she faces a dilemma. Now she has to work for someone that she has just rejected.
Yeah,
that can make things awkward.
Yeah, and in the workplace, that would be, I mean, in just the straight overt, especially if it's straight overt, it's sexual harassment because it's quid pro quo sexual harassment. Sleep with me and I'll give you a benefit in my workplace. That's just sexual harassment. But if it's more implicit, right? If she let's just assume this is what's going on in her own head, right? She is contemplating whether to sleep with this person. And as one of the reasons she's thinking about this, among others, is that it might help me and benefit me in my career. It might help elevate me. It's like, is that a proper consideration for her? And if she goes into his arms, and he may or may not know that's her motivation, but if he goes in, is she allowed to make that decision? And if he knows or has reason to believe that's the decision, is it okay for him or is it not okay? So I think in the overt case, you have a problem. In the more implied case, I think, unless you want to just make the argument that a woman should never be able to sleep with her superior in the workplace ever, if you want to say that she's deprived of that choice, then I'm on board for that argument. I just want to know if that's the argument. Should a woman be able to sleep with her boss under any circumstances? Is that an okay decision for her to make? Or someone in superior position in the company?
Yeah, it's hard because it seems like there's no problem if she's fully game for it. The problem lies in her not being fully game for it, and her having, let's say she could have concerns, even if he doesn't say them outright. She could have concerns that there would be other backlash if she didn't.
Yes, in that scenario, then,
because then it's not a quid pro quo, but there's still like oh God, but what's going to happen to my job? I really need this job, like if I don't, so many bad things can happen to me if I don't. You know what I mean?
I think I understand what you mean. I think to the extent that he is communicating that pressure, then that poses a problem. Because then I think you have sexual harassment to the extent that he is communicating one way or another. If you don't sleep with me, I will penalize you in my career, in your career.
Yeah.
But if she is flirty with him and he's flirty back and she's flirty, and one of their motivations is advancement of career, among others, then even if he's aware of that, then I think that's probably okay. I mean, I think it's very dangerous territory, to be honest, as a lawyer, If the superior came to me in this hypothetical, my advice would be just don't do it. It raises too many problems, right? There is a hypothetical way for you to get to a place, but if she at any point says this turn bad, if this turns bad, she can burn your ass. Yeah. And I might be able to save you, possibly, but you're going to lose your job. You're going to lose your career. Mm-hmm. It's so my advice as a guy would be, don't do it.
Don't do
sleep
it.
with subordinate.
Yep, I agree. Britt Cormier says women have, quote, married up since the start of history. If this is not okay, then the royal families would not be a thing. Hard to find a peer to the king. That's true.
Yep.
Kind of true. Yeah. Anti-commie says, bruh, casting couch discussion and lots of freely given and freely received, and hope it wasn't a lay has me cracking up.
Well, we talk about a wide range of topics here.
I know we do. We really. And then he says again, anti-commie says again, the standard should be don't dip your pen in company ink. All employers should have relationship clauses like many airlines do.
The expression goes far back for that reason. Yeah. Danger, Will Robinson. But then, of course, there have been successful relationships that emerge from workplaces.
Yeah. And then Britt Cormier also says, do not fish off the company docks. Great advice. Nope. I completely agree. All right, let's finish up this article. But this has been an excellent hypothetical discussion and policy discussion. All right. Okay, so Carlson further described Portnoy as a rich, famous, and powerful person who uses his power in a way that is harmful to other people. Carlson then pinned his article to the top of his Twitter account. Okay. An insider representative then gave an interview to Variety in which insider welcomed a lawsuit and claimed that such lawsuits are, quote, the cost of doing business. The effects on Mr. Portnoy's reputation have been pervasive and continuing. As a result of defendant's defamatory statements in use, Mr. Portnoy has suffered significant and irreparable damage to his reputation and profession, as well as embarrassment and humiliation. To any reasonable reader of the insider stories, the clear and essential gist of sting of the defendant's overall publications is that Mr. Portnoy is a rapist, an abuser of women, and a person who secretly records women having sex without their consent. Yet, defendants intentionally ignored and or intentionally buried in their stories actually provided and or readily available and known evidence establishing precisely to the contrary. Simply put, defendants slanted material of facts in their published stories pursuant to their preconceived agenda to harm Mr. Portnoy. In doing so, defendants ignored, for example, and without limitation, that the sex which took place was fully consensual as reflected in text messages of the women themselves, that the women themselves either enjoyed and or never protested their encounters as reflected in their text messages, and that all recordings were done openly and notoriously with the full knowledge of the women who voiced no objection whatsoever. Okay. I mean, there's a lot of and ors ignored and or intentionally buried, things that they knew / should have known. I don't know. I mean, I don't think we need to read through the count 1 defamation and then count 2 invasion of privacy.
Scroll through the count 1 just real quick because they gave a bunch of specific statements, I think.
Okay. Yeah, so it does
we don't have to read them, but
these are statements that he says were false.
Yep.
Including, I was literally screaming in pain. Young women say they met Barstool Sports founder Dave Portnoy for sex and it turned violent and humiliating. That was the title, obviously. B, 5 women have now told Insider that Portnoy filmed them during sex without permission. 4 of them said that the sex was recorded, started consensually, but then turned that 4 of them said the sex that was recorded started consensually, but then turned violent and frightening beyond what they would have agreed to had they been asked. Okay, so here's a question. How did they know it was recording or that it was recorded? At what point did they know that it was recorded? I think the fact that they know and they are telling Insider suggests to me that they knew at the time that it was being recorded.
This is a pretty good point. How would all 4 of them know otherwise?
Yeah, It seems like, and
I mean,
also
either
because,
they were told, or the video camera was super obvious, which would be fine in terms of the law.
And I think that earlier on too, in the complaint, I can't remember if it must have been in the introduction then before you joined in, but I think at least one or two of them, some of them, maybe all of them, he had like sent them videos of him having encounters with other women. So that also kind of suggests, you know that this is going to happen if you come and hang out with me and have fun, happy go fun time, so to speak. So, I mean, it doesn't seem like he's actually surreptitiously recording these women based on what's been said in this complaint. So, assuming that that's true, it seems like there's been a suggestion here that they were illegally recorded, according to the articles, but that under Massachusetts law, it seems that was not the case. So, even if the roughness of these encounters is all true, even if they said that they, did not consent, and at some point they somehow revoked their consent during the encounter, if these articles are also alleging that he illegally recorded them or surreptitiously recorded them, and that proves to not be the case, then you have a defamatory statement.
Yep.
So, and the thing is also is that could be a case of actual malice, because all insider reporters would need to do is ask them, if you were secretly recorded, how did you know that you were secretly recorded? How did you find out?
Yep.
You know what I mean?
Yeah. They for sure didn't ask that question.
Yeah. Yeah.
Because
American Legend.
Because it's just listen and believe.
Yeah. 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 American Legend, today is my birthday. Thank you for the streaming. Hey, happy birthday. I hope you have a wonderful, wonderful birthday, and that you either got to celebrate over the weekend, this past weekend, or this next weekend, or maybe both, because that's the benefit of having a midday birthday, is you get two chances to celebrate. So I hope you're having a wonderful day. So back to the recording. Yeah, no, I that to me seems like the strongest part of this lawsuit. Okay, another statement was that Portnoy says is defamatory is C. 3 more women say Barstool Sports founder David Portnoy filmed them without asking during sex. The sex during their second encounter was far rougher than she had anticipated or would have agreed to had she been asked, was the fourth statement. E. He attempted to have anal sex without her permission. F. Mr. Portnoy took, quote, a sexual encounter that began consensually and turned it violent without first asking his sexual partner for permission. G. Portnoy is, quote, a rich, famous, and powerful person who uses his power in a way that is harmful to other people. Where's the lie in that? Because, harmful, who uses his power in a way that is harmful to other people, that's an opinion.
Yep.
Yeah, G I don't think is a statement of false fact. But so far, everything else seems to be a factual statement that is made, that if it's a lie, could be defamatory. H, he didn't ask. He just tried to force it in. Okay. I, she told him no 3 or 4 times because she, quote, knew it would have been excruciating. Okay.
I mean, that's a statement of fact.
That is a statement of fact. That is a statement of fact that more than suggests that there was no consent.
Yep.
And if that's not true, yeah. So
it's on tape, apparently. So if you really said no and he really kept going, since it's apparently on tape, it seemed like you have pretty good evidence for a criminal charge.
I mean, no.
There's a tape.
Imagine being a juror. Oh God.
Well, if I'm a juror, if the crime is rape and I have a video of the sex occurring with the woman saying no, and he keeps going, I'm going to be thinking to myself, this probably looks like rape. Yeah. So that'd be pretty good evidence.
I'm having a hard time with this, but I mean, it's incredibly relevant. Holy crap. It's
Now, of course, this could be rebutted because, again, it could all be a play, but you need to show text messages to that, and you need to show you definitely want that in writing, by the way, if you're going to go down this road, so you don't run into these problems. Because we had a conversation in advance, and she said that she wanted to simulate a rape encounter, and so we agreed on a safe word, and no wasn't it.
Yeah,
I mean, you want something in writing about that, I think.
Yeah,
just to show that that's what she's asking for. So
yeah,
you can defend yourself when it comes time.
But also, if he is saying that she never said no 3 or 4 times because we can forget the rest of the sentence. If she says she told him no 3 or 4 times because she knew it would have been excruciating, but he says she didn't say no 3 or 4 times during the encounter, and it was all filmed, not surreptitiously, it was all filmed. That means that there's video evidence proving the falsity of that statement.
Yep.
But again, would Insider have known that? They would not have seen those tapes.
Presumably not.
So it would go to the falsity of the statement, but the question is meeting the actual malice standard. So so maybe the tapes don't come in as evidence.
No, not unless they had access to them. Well, unless they were given access to them prior to the but they were told the tapes existed. So I was like, do you have the tapes? Would have been a reasonable question. If no, then fine. But did they even ask the question?
Yeah.
Yeah.
Because the question is, did she have a copy of it? That would be one of the first questions. Did she have a copy of it? Did they ask for it? Interesting. Yeah. Okay. Anyhow.
People lie sometimes, even when things are on tape. Emily D. Baker told the story of the only, I believe she said, was the only criminal perjury charge she ever had. There was a guy who claimed to have fallen down in a bus and got injured, and the whole thing was on tape. And they even went through it with him on tape. It's like, where is this? Where are you falling down? Where is this happening? Because it wasn't. And he still said, yeah, I was injured. He still stuck to it. And they gave him multiple chances to bail, and he wouldn't bail. So eventually they charged him with criminal perjury because none of this happened. It's on tape. So people will say some really crazy shit, apparently.
That's nuts.
Yeah.
That's really nuts. You would think that I mean, sometimes people are pretty stupid.
Yeah.
where there are easily rebuttable claims with simple documents and a few follow-up questions. I've caught people in weird lies before. Interesting. Yeah, interesting stuff. There was one case where this married couple that ran their own business on a shoestring, they used a false notary document or a false notarization of a particular document, and I think they didn't realize that you can find the person whose notary number is on the seal that you use, and you can look them up and you can talk to them and you can ask them if they actually notarized the document. So when I had a fun moment where I was in deposition with one of them, and I was like, can you explain to me why this person said that they didn't notarize the document? Can you explain to me where you got this? Can you explain to me who did this? And they were just like, I'm like, so what is your understanding of what a notary is and does? And they're like, well, I don't really know. Somebody just like gets a stamp and puts it on the document and boom, that's it. And yeah, anyway, sometimes people are dumb. All right, let's continue through these comments. Okay. Jay, that was not the sex she consented to, is another statement. I guess that's factual. K, these women told Insider the experiences with Portnoy turned frightening and humiliating and had taken a toll on their mental health. 2 of the women also said Portnoy filmed their encounters without their consent. Yeah, again, the filming without consent is the strongest part here. Because, you know, even if they were consenting, it could still be frightening and humiliating because I'm not going to shame anyone. You know, some people get their rocks off to that kind of thing, you know, with fear and humiliation. So, and maybe it did actually take a toll on their mental health. Maybe the fact that they technically consented to something that they think later that they shouldn't have, maybe that took a toll on their mental health. That's also possible too. Yeah. So again, the filming without their consent is the thing that's pulling most weight here. L, I kept trying to get away and he was like, stop running away from me. Stop running away from me. Okay. That's a factual statement of what happened. M, she first became uncomfortable when Portnoy pulled out his phone and started filming her without asking permission as she performed oral sex on him. He pulled out his phone and started filming her. That right there is pretty apparent, I think, to someone that you are being recorded.
Yeah, I would think so. I mean, one pulled it out from where, one might wonder, for starters. And yeah, I think that you would.
I'm assuming his pockets.
Yeah, but I think that you would kind of know he's pulling something from his pockets. And yeah.
Well, if she's recounting it to someone else, she knew it happened, right?
Yep.
Like she saw it.
Yep.
So yeah, this tells me more clearly than any other statement so far that he was not surreptitiously recording them, that he was doing this in a pretty apparent way. And, you know, and especially in the context of him having sent the videos ahead of time of him with other women, that suggests this is going to happen with you and me. I mean, if they weren't into that, not to say that this would be required if they, you know, for them to not have consented to being recorded, you know, if they weren't into being recorded, they could say ahead of time, like, hey, I know you've recorded yourself with other women before. I'm not into that.
That too.
You know, going into it or during the fact.
Yep, absolutely.
So more to the point, in the moment, they could have said that. And that is what the law requires in Massachusetts. Chuck Strum says, the rich and powerful can become victims very quickly if they aren't vigilant. That is why Hollywood agents employ Ray Donovan types.
I have no idea what that means.
Yeah, I'm not sure either. That second part. I mean, I get what you mean in the first sentence that you know, people that are rich and powerful can definitely be taken down very quickly because of situations like this. I would agree with that. Anti-commie says, oh, stamp. She was bragging how brutal guy number 2 was to Portnoy, and she is down for this as she is chasing celebs to bang, probably hoping to catch F trophies. It's possible. Definitely possible. Let's finish this. All right. And another statement is, another who has had depression said she was suicidal after the 2 had sex. Okay, so he seems to be implying that she wasn't suicidal afterwards. Oh, she was both choked and filmed without advance permission. So being filmed doesn't actually necessarily require advance permission if you see that it's happening and you don't say anything about it. So P, 3 of these women said they had sex with Portnoy, now 44. and that the encounters turned into frightening and humiliating experiences that have taken a toll on their mental health. 2, including Madison, said Portnoy both choked and filmed them without advance permission. Again, without advance permission is not necessary under Massachusetts law.
Yep.
And that's, I wonder too, because I'm inclined to say that with a story like this, they probably should check with a lawyer to see if that is against the law in Massachusetts, right? Because making this kind of a suggestion about this being, illegal activities or I don't know. What do you think, Kurt?
Yeah, I'm the biggest weakness for the majority of this, and there might be an exception to one of them, which might be enough for him to win on a motion to dismiss. But the biggest problem for me is what was being communicated to the lawyer or to the newspaper, because he says he gave him material.
Yeah.
But that information about what exactly that is would change the analysis. And he mentions it. He says it exists. So I don't think there's a problem with the defendant bringing it in, be like, well, here it is. Here's what we had from him. And then we had these other statements from them, and we in our judgment felt that we went with this. We considered it. We rejected it.
I think as to the aggressiveness of the encounters, I think you're probably right. I think as to the recordings, the way in which the narrative is told about the recordings, at least that we've seen so far, suggests that these girls women, someone in the chat, I think earlier, was pissed about that. It's true. They're women. They're adult women. So these women ostensibly knew they were being recorded. And that seems to be the big deal, especially in the second article, is that they are being recorded without getting advance permission. But it seems like no one at Insider stopped to think, well, is that actually legally required for this to be, because the shock value of the story would be that he's doing something illegal, right? And that seems to be what they're going for. And so it seems like they would have some kind of a responsibility, I would think, to determine whether or not the way that they're framing this is proper. And with that comes a certain legal analysis into the acts. And a quick 10-minute research on Massachusetts law would show that they don't need advance permission.
Right.
And that these women knew they were being recorded and didn't say anything, which again, under Massachusetts law, is implicit consent for being recorded, excuse me.
Yeah.
Okay. Let's push on. We are getting close to the end. The stories are defamatory per se, in that the stories falsely accuse Mr. Portnoy of having committed a crime or crimes, including sexual assault and unlawful recording.
They could be read that way. I mean, but yeah. Or not. But yeah.
I think to a reasonable person, yeah.
Yep.
Because I mean, it's to a reasonable person that isn't going to go and do a legal analysis. Yeah. To say, like, if I weren't a lawyer and I read, David Portnoy recorded a bunch of women during sex without asking them, that sounds like an unlawful recording if you don't know where to go to analyze the law around it, to any reasonable person, I think.
We can skip ahead to the next cause of action if you want.
Okay. All right. Invasion of privacy. Plaintiff alleges okay. We don't need that first paragraph. Okay. Massachusetts 214 section 1B guarantees Mr. Portnoy the right to be free from unreasonable, substantial, or serious interference with his privacy. No. Mr. Portnoy's privacy rights. What's that?
This is just a non-starter for me because the text messages that they're releasing were the text messages with the women. The women are giving them the text messages, which they can do. It's a non-starter.
Well, but the question is whether or not Insider can publish them.
Oh yeah, I have no problem with that. Yeah, I have no problem with that. It's her information. She's revealing texts that were sent to her, and she is revealing them to a third party. And she can do that. And the texts are authentic, so they're truthful by their own terms. So I have no problem with this. This is a non-starter for me.
I don't know. I don't know about that. I don't know that I agree with that, because I think that there's a difference between them sharing it with the women, sharing it with Insider, and Insider publishing it. I think there's a difference. It says defendants releasing
Either
and
way,
publishing.
It's communication to a third party, right?
Well, because they're involved in the underlying act themselves, the women,
but not the newspaper. When they communicate to the newspaper, they're communicating to a third party.
Yeah. So
the moment they gave the chats to the newspaper, even before they published it, they were talking to a third party.
So that would imply, though, that okay, let's put it in a different kind of hypothetical.
Sure.
Medical information. You have a right to give your medical, or well, let's see here. No.
If we're going to go to HIPAA. HIPAA only covers protected persons, it only covers protected entities. So yes, legally, if I give my medical information to you and you republish it, I'm SOL.
Yeah.
I'm shit out of luck. Yes, you can republish the medical information I gave to you about myself. You can do that.
Right. Because it's only about you. But where it involves you and someone else, that other person still has rights to it. Let's say it's a married couple, and we're talking about marital privilege. Both parties have a right to that privilege. So one person can talk about it. The other person can restrain them from talking about it. The other person can restrain the other person that their spouse talked to about it.
I'm not sure, but I think it might just be an evidentiary privilege. I'm not sure it extends beyond that. I'm not sure that you telling your friend, if I know that you're telling your friends things that I said to you in marriage, I'm not sure that I can get like a restraining order against that. I mean, I can prevent you from bringing it into court, even though you told your friends, but yeah, I'm not sure about that one either.
To me, there seems to be a distinction. Well, and I don't know, maybe I'll take a look at some case law on this one. Yeah. But it seems
you've already proven me wrong once today, so let's go for two.
Well, you've also proven me wrong once today. We're 1-1. Okay. Defendants releasing and publishing of Mr. Portnoy's highly personal text messages and social media messages amounted to an unreasonable, substantial, and serious interference with an invasion of Mr. Portnoy's privacy in violation of Section 1B and of his common law rights to privacy. As a result of defendant's invasion of Mr. Portnoy's privacy, Portnoy was humiliated, felt invaded, and ashamed, and suffered a violation of his privacy, dignity, and personal integrity.
Yeah, I'm just giving that one a big X for me personally. It's a non-starter from my mind.
As a result, as a result of the defendant's invasion of Mr. Portnoy's privacy, Mr. Portnoy has suffered harm, injury, and damages.
Okay, therefore I want some money.
Yeah. So he's going for damages in the amount assessed by the jury on each count, including fees, costs, and interest. Okay. So basically whatever, okay. And this is Exhibit A. I'm just going to scroll through this quickly, just a little bit of it. So you can see that this is a copy of the article. Mm-hmm. And then Exhibit B is down here. I'm still scrolling. Okay, Exhibit B. 3 more women say. Okay, so this is the second article. So, okay.
Yeah. Well, I at least to my mind, I think where this seems to be going is I guess, a motion for summary judgment, because I'm anticipating what the defense is going to look like. So I'm hypothesizing into existence, but based on some reasonable guesses, I think. And then I think a motion dismiss, motion for summary judgment comes. And I think the odds are not bad that you get it. I think we have problems with the reckless disregard element of the thing.
I think that as to the aggressiveness of the encounters, I agree. I think that as to the unlawful recording element, I disagree.
Okay, yeah, you might have a point.
Because a reasonable person should have asked them, if you knew that you were being recorded, how did you know? Did you know during the time? Did you know? Did you only find out afterwards? You know what I mean? Like I think that those questions should have been asked. And if they were, I want to know what the answers were. If they weren't asked, I want to know why.
Yeah, this is fair.
But fair point. Yeah, because the way that narrative is told from the parts that are taken from the articles says, or it implies that they saw it during the act. They knew what was going on during the act and didn't say anything about it, which under Massachusetts law is effectively giving consent.
Yes.
So, and the thing is that I think insiders should be doing some research, some legal research on that before they go ahead and publish something like that suggests that he's doing something illegal.
Yeah. So, okay, fair enough. So then the defense becomes what we. I don't know if this is all that they said, but they at least said this much: is that we said they didn't obtain permission in advance. We weren't saying that was legally required. We were just saying that they didn't do that, and we think that, so we're just reporting on something that was true. He didn't obtain permission in advance. We weren't implying it was criminal. We were just noting a fact. And so you're trying to do like a defamation by implication kind of thing.
Except for this title. 3 more women say Barstool Sports founder Dave Portnoy filmed them without asking during sex.
Well, strictly speaking, that might be true. He didn't ask. He was just filming, which is, yeah.
Yeah, but the implication of that is that he's recording them without their permission.
Yeah, so it's trying to be very, very clever, I guess, in the way you phrase things, and I guess to show how you can phrase things a different way. So someone could read it that way. It's like, well, that's not what we said. We just said that they didn't give it consent or advance or whatever. So it's like, yeah.
But what would a reasonable person think, having read that? I think any reasonable person would read that and say, looks like he's recording people without their consent.
I think you might have a point. I think you might be right. You might be right. So we'll see how it plays out. But I'm definitely willing to be a little bit more open-minded on that going into the future. So fair enough. I think you made a compelling case for me to not foreclose it immediately.
Sounds good. But I mean, yeah, it'll be interesting to see as this kind of continues on. Because I do think it is going to go into discovery. I do think that it is either going to settle or go all the way to trial. Who knows? Maybe we have Cardi B 2.0, yeah, anyhow. But it's a very interesting case. I'm going to be interested to continue tracking it as it goes along. So anyhow, any other thoughts before we head out?
Not in particular. I really enjoyed the discussion. I really enjoyed the thorough analysis. It made me think and, potentially correct me on a motion to dismiss standard, because I think on balance, you are more right. And I'm improperly importing things into that standard. So I do appreciate the correction. So, hey, I learned something, and that's always a positive experience.
So did I. I mean, it was you also had some fair points of that the defense can introduce some evidence to sort of try to foreclose a lawsuit with a motion to dismiss. So that was a fair point that I wasn't particularly clear on.
I've enjoyed streaming so much I don't particularly want to end, but we can't stream forever.
I know. And this has been almost 4 hours, so holy crap. I didn't anticipate it would go this long. Okay. Alrighty. Well, if you are new here, my name is Alita. This is Legalbytes. If you haven't subscribed yet, what the heck are you doing here? Subscribe, like the video, subscribe over at Uncivil Law. Because Kurt is awesome. He goes in depth into a lot of different lawsuits and crazy stories and whatnot. Yeah, he's got a really, really great analysis as well. So, and earlier we were joined by Nate the lawyer. Subscribe to him too. If you haven't already, what are you doing with your life? Anyway, with that, I will say goodbye.